which I normally am able to. So I don't know what's going on. Because of that, we are going to do a giveaway. To thank you all for 30,000, we're going to do a giveaway at the end of this show. So stay tuned. I'll give you the details and let you know what we're giving away. But thank you guys again. That's a huge milestone for us, and we're just blown away. All right. I just want to make sure. Can you guys all see me? Is everything working well this morning? There we go. Did we miss everything? Did you guys hear any of that? I don't know what happened, guys. We had some sort of technical difficulty. I think you missed all of my introductions and everything. So if you're hearing me now, please let me know. Didn't hear anything. A lot of hellos. I heard, I think. All right. Let's do it again. Crazy Mom RN. There's Ritter. Crazy Mom RN says, redo it, Josh. Redo, Josh. All right. Let's redo. Good morning, everybody. Welcome to Sunday Fun Day from Courtroom Confidential. I'm your host, Joshua Ritter. Thank you for joining us on the fastest growing true crime news channel on YouTube. Hello to everybody in the chat, Becky B and Crazy Mom RN and Helen O'Hara White, June Sidlauskas, Black Witter. I love a bit of mayhem. Me too. I didn't know what was going on. I'm sitting here, I'm talking, and everybody in the chat is acting like they're still waiting for me. So I apologize for that. I don't know what's going on. It's the streaming gods are against us already this morning. But 10 minutes behind, Johnny Knoxville says, I was here and ready to go, but for some reason the internet was still catching up to us. So good to see you all. I'll introduce myself again. Josh Ritter. I was a LA County District Attorney for 10 years. I left the office, went into private practice. I've been a criminal defense attorney for nearly as long. This is Courtroom Confidential, where we do our very best, we hope, to give to you a perspective from both sides of the courtroom. That's really the goal of this channel, the mission behind this channel, why we set out to do this. So thank you all for joining us. Hello to everybody in the chat. Hello to everybody in the replay crew who's going to be watching this in the future. Appreciate you as well. And if you're watching on replay, let us know where you're from as well. If you're in the chat right now, just say hi and tell us where you're from. Big news already this morning. And if I'm repeating myself for stuff that you guys have already heard, let me know. But I'm just going to go through the whole thing again. I woke up this morning. Tiffany whacks me on the arm, shows me her cell phone and says, look, and it shows exactly this, what Copper Horse is saying, that we just passed 30,000 subscribers. Blows me away. Just absolutely, just so touching and so encouraging, the support from everybody. So 30,000 subscribers is a huge milestone, and we appreciate all of you. It's only because of your support that we're able to continue to do this, and we're encouraged to do it and try to make it a little bit better and provide you with a little bit more every single day. So thank you so much for that. Because of that, we're going to be doing a giveaway. So stay tuned to the end of the show. I will give you all the details, but as a big thank you, or as much a thank you as we possibly can, we're going to do a giveaway to somebody listening in honor of us passing that 30,000 subscriber threshold. And already, I have some big thanks to Robin Hood and to Kathy for being so generous to donate memberships this morning. So thank you so much, Robin Hood, for the Courtroom Confidential memberships, and to Kathy as well. Appreciate you all, and appreciate you guys being part of the membership program. And thank you, Annalie Finch, for the super sticker, and Voodoo Vicky for the super sticker. You guys are fantastic. And Rando became a YouTube member. All right. Here's the plan for today. Lots of messages. Because we took a week off, we have a lot of messages, and my feeling is you take the time to leave a message. I'm going to take the time to answer it. So we've got a lot to dig through. So we're going to try to get through them as quickly as possible so that you can actually have a rest of your Sunday. All right. Should we jump right into it? Let's do it. Let's pray too that the glitches in whatever was happening with our stream has not carried over to the playing of these messages. All right. Here we go. Hold on. You hearing that? Nope, not hearing it. Hold on, guys. Sorry. Oh, I have to remove other media. Oh, I see what it is. Kaylin, they will only let me do so much at once here. Okay, now tell me if you can hear this.
Hey, Josh and CC crew. Yes, I know. I'm sorry about my thick Southern accent. I've had a question for a few weeks. It's really, well, most of my life, but mainly for a few weeks. Back when we were talking about the Manson case, since they discovered that he had never actually done any of the violence or the killings, how come he got charged with it and got put life in prison? Could you explain that to me, please? Thank you and have a great day.
Great question, Kelly. Thank you so much. I only wish I knew where you were from so we could throw you up on the map, but thank you. Great question about Charlie Manson. A lot of people have asked this because people are curious. And by the way, this wasn't just a small issue at the time. It was even a little bit controversial at the time as to why Charlie Manson, who prosecution never alleged even entered the home where Tate was killed. He did apparently enter the La Bianca home, but never took part in the murders. How in the world could this man be charged with murder when he never pulled the trigger, never held a knife in his hand, and never even, there was very little evidence as to whether or not he even ordered the killing. So how in the world is he charged with this? And not, by the way, just sentenced to life without parole. He was sentenced originally to death. That was converted to life without parole later on because of a change in the law in California. But putting that all aside, the biggest reason for this is the conspiracy charge. Under the conspiracy charge, I'm just going to read it to you really quickly. A defendant may be guilty of a crime if he commits the crime or aids and abets in the crime. Well, how do you decide that? One, the defendant intended to agree with the other defendants to commit the crime. So we saw this a lot in Lori Vallow, right? Did she agree with the commission of the crime? Yes. Two, at the time of that agreement, the defendant and one of the other members intended that one of them would commit the crime. So they're agreeing to commit the crime. At the time of the agreement, one of them actually intends to commit the crime. You follow this? It's a little nuanced and a little bit in the weeds. And then three, the defendant, so Charlie Manson, even though you're a part of a conspiracy, you're agreeing to it, you know that one of you is going to commit it, you actually have to do this third thing, which was commit an overt act. What is that? That is some act in furtherance of the conspiracy. So it's, in other words, you can't just sit around on your hands and go, this all sounds great to me. I hope you guys have fun killing everybody, but not contribute in even the smallest way. Well, how did Charlie Manson contribute? The prosecution contended that while Manson never directly ordered the murders, and let that sink in, they never said he actually ordered these murders, his ideology consisted of an overt act of conspiracy. So in other words, his teachings, his helter-skelter, his philosophies they felt were enough for overt act. That was very, very controversial at the time, and it's still kind of controversial to today. I'll be quite honest with you. This was such a horrific crime. It shocked California and the nation that I quite frankly feel like people just saw past a lot of the maybe intricacies of the law and said, this man's behind it. He's the mastermind. He's an absolute psychopath and he's dangerous and we're going to hold him responsible. But it is interesting and it's a great question. And thank you so much, Kelly, for kicking us off, because it is not a small issue as to why he was ever convicted, something that he's continued to complain about and legal scholars continue to talk about to this day is, was that the right thing to do? All right, let's move it on and hope that everything moves smoothly from here.
Hi, Josh. This is Pam calling from Michigan. I have a two-part question. I've been listening to the Lori Vallow trial, and my first part of the question is, can an appeals attorney down the road after hypothetically Lori is convicted, can he say ineffective representation of counsel? I think that's a phrase, that Lori didn't effectively represent herself. So can that be brought up on appeal down the road if she's convicted? The other part of my question is, I noticed that the prosecutor, I think, is getting away with a little bit of things that I would think the defense would be objecting to, but isn't. And that kind of goes into the appeal thing. Can that be brought up on appeal that it wasn't objected to? And can that also be something that's brought up down the road that potentially could get her sentence commuted or lessened? Not that it really matters, but just hypothetically, because she's representing herself, she's kind of opening herself up, or is the state opening themselves up to potentially appeals? Thanks so much. Have a great day.
Thank you so much, Pam. And Pam from Michigan, we're going to throw you on the map. God, I love this map. So grateful to Kaylin for putting this thing together. You see that? I'm going to be happy when this map is just littered with dots. All right. So Pam from Michigan, you ask an excellent question about Lori Vallow. And it's not, it's a very common question. A lot of people are concerned that somehow by her representing herself, this is going to create an appellate issue and she's going to somehow bamboozle her way out of all of this, even though we now know that she's been convicted in very short time for the murder of Charles Vallow. To the second part of your question, first of all, like, would things like not objecting, putting aside that she's representing herself, but would things like not objecting at points where a normal attorney might object create an appealable issue? The answer to that, putting aside whether or not she's representing herself or not, is no. And that's why you see attorneys object, is you cannot preserve issues for appeal unless you put something on the record for the Court of Appeals to review. In other words, if an issue flies by and nobody objects to it and there's no record made of that issue, there's nothing for the Court of Appeals to consider. You cannot have them go back and go, well, hey, we want you to look at, page 342, line 7. We think an objection should have been made there. And because of that, we want you to second guess what the attorney was thinking. Not the way it works. That's why so many times you see attorneys making objections and you may be rolling your eyes going, why are we listening to this moron continue to object? He's making sure that he's making a record on appeal is a lot of times what's happening there. But to your bigger question on, can she, just by representing herself, create an issue of, and the term is IAC, ineffective assistance of counsel. Can she create an ineffective assistance of counsel issue by the fact that she represented herself and represented herself poorly? It's a great question. The short answer is no. Here's the reason why. The whole case law comes back to a Supreme Court case called Strickland v. Washington from 1984. And these were the elements. It's a two-part test for whether or not there is ineffective assistance of counsel. One, the trial lawyer's conduct fell below, quote, an objective standard of reasonableness. So something about the way that they were conducting themselves as an attorney was so far below an objective standard of reasonableness. And two, there was a reasonable probability that but for counsel's unprofessional errors, the outcome of the criminal proceeding would have been different. You can see by those standards that there's a lot of discretion there, right? It's a lot, there's not some sort of bright line. It's a lot about reasonableness and objective standards. So a court would have to take a look at, putting aside again that she's representing herself, an attorney, any attorney's conduct, and say, objectively, was this fell below a standard of reasonableness. That's got to be pretty bad. That's got to be pretty bad, because there's a lot of attorneys who just aren't that good, but they could fall into that category of objective standard of reasonableness. And then they have to say, okay, even if objections weren't made, even if witnesses weren't examined in a way that we felt was meeting this standard, did it change the outcome? And that's really where most of the wiggle room will take place for the Court of Appeal, is saying no, because even if she were the Alan Jackson of her time, she's not going to turn this case around, because there's so much convincing evidence. We don't feel that her representing herself really had that much of an effect on the trial. But the real answer in all of this is you cannot create your own appellate issues. You cannot say, I want to represent myself, take all of the waivers of understanding what that means, and then just plan or accidentally do such a horrible job that you get yourself a new retrial. Not the way it works. You want to jump in the tank and swim the sharks, you're going to swim with the sharks, and you suffer the consequences. And that doesn't mean that you somehow get a back end benefit from all of that. So great question, Pam from Michigan. Thank you for being the first one to put us on the map today, and I appreciate that question. Let's move it along here.
Hi, Josh. This is Suzanne from Texas. I'm an intel analyst for a local police department, and so I read a lot of police reports, and most of them are lacking a lot of detail. That's just a fact. The city is about 400,000 people, and the officers are busy, so naturally they just put kind of basic information. My question is this. I've been watching the Sementilli trial, and I noticed that one of the tactics used by defense attorneys is to kind of point out the lack of detail in police reports as being some sort of a gotcha. Is that from not realizing that police reports sometimes are very basic, or is that strategic? Do they already know that that's pretty common, but are choosing to pretend like that's not common? Is it strategy? Or is it just a lack of knowing how police reports are generally written? That's all. Thanks. Bye.
Thank you so much, Suzanne from Texas. Let's put Texas on the map. Appreciate you calling in calling in earlier and giving us a question to answer this morning. Talking about the Monica Sementilli case. This was a very really good case that I think got overlooked a little bit. It got caught up, kind of lost in the crowd of all the big cases we've got going on, but really fascinating case about her conspiring with her lover, who was her racquetball coach, who was also a former porn star, to kill her husband, who's a celebrity hairstylist. And she was in on it, but she never, the co-conspirator couldn't say that he actually heard her give the orders, on and on and on and on. Very intriguing case. And one of the lawyers involved in that was her lead attorney was a lawyer by the name of Leonard Levine, who I know well, been around for forever. And he did, as Suzanne very acutely observed, the kind of typical defense attorney tap dance, which is, what do you do with a witness who's a police officer, and how do you impeach that person? And do you go back through their report and chop it up and talk about how it is lacking in detail? And is that because they don't appreciate what police reports are all about? or is that just part of the game? The answer is they know what police reports are all about. And of course it's part of the game. And every attorney does it. And it doesn't mean that it's some sort of underhanded trick. It makes sense. But it's kind of a fallback and what you go to when you really don't have all that much to get into with a police officer. Police reports, for people who've never seen them, are incredibly brief. Many times the first responder, especially, not the supplemental reports and investigative supplemental reports done by detectives and investigating officers, but those first responders, the cops who respond to the radio call and they're out on scene and they have to write a report, they might write a report that's 2-3 paragraphs long, and it's just bare bones facts. I arrived on scene. I spoke to so-and-so. They said that somebody got shot and the description of the suspect was X, Y, and Z. And when they get on the stand, then the defense will go, and it's things like, first they set them up. Is your job to write a report? And isn't your job have you reviewed that report? Have you reviewed it for thoroughness and completeness? Is there anything you'd like to change about your report, officer so-and-so? And that's, this big dramatic pause as if there's something in their report that they need to change. No, there's not. I've reviewed it. Yes, it's everything. But you didn't include the hair color of the suspect, did you? Don't you think that that's important? Isn't that something that would have been important for the other officers to know? Why did all of this kind of theatrics? And I'm not trying to make light of it. It's fair game. It's part of cross-examination. But you're absolutely right, Suzanne. It is not a lack of understanding of what a police report is about. It's not a lack of understanding how busy these guys are, and that when they go home at the end of their shift, they've got a dozen of these reports to write. It's about cross-examination, and it's about whatever value that holds for the jury. If the jury wants to say that somehow because they lacked certain elements, that means that report is not great and therefore the officer's memory is not that great, they can chalk that up to that. That's part of holding the government's feet to the fire. But for the most part, it's a lot of kind of, defense attorneys can do this walking in their sleep sort of stuff, cross-examine a cop, because exactly the first 12 questions you're going to ask because they're all the same. But great question, Suzanne from Texas. Thank you for that. All right. Let's move it along here.
Hi, this is Marianne from Edison, New Jersey. I'm calling to find out if you noticed the look on the judge's face at Lori Vallow's trial when Kay Woodcock said her last statement. Please go and check it. It's worth $1 million. Thank you.
Thank you so much, Marianne from Edison, New Jersey. First of all, let's get you on the map. There you are. Thank you so much for calling in. Marianne, you said I got to check out his face, and I did. Because you gave me the homework, I went ahead and did it. So let's go ahead and take a look at it all together. Well, let me do the video. I'm going to present the video here so we can see the lead up to this thing. But that was the look on his face. Here we go. What am I doing? Here we go.
Ms. Woodcock, did you see or hear or personally witness me conspire with Alex Cox to kill my husband, Charles Vallow?
No, but I saw a ton of evidence that did.
Thank you. No further questions.
All right, redirect.
And then you see the look. Well, how do I do this? Then you see the look on this poor judge's face. And that is the look. Because you want to talk about who is our last question about defense attorneys. Pam asked about defense attorneys. No, pardon me. Suzanne asked about defense attorneys and, asking questions. That is, by the way, not the question you want to go out on if you're a defense attorney. You never saw any you never saw any evidence. Oh, I've seen plenty of evidence that you're guilty for this. Thank you, nothing further. That's how she ends it. I just love it. And the look on the judge's face, I imagine, was reflected by the look on a lot of people's face on that jury. So thank you so much, Marianne from Edison, New Jersey, for pointing that out. I had missed that part, but when I didn't know what you were talking about at first, and I'm looking through the video, and then when I saw this look on his face, I'm like, oh, that's absolutely epic and classic. And thank you so much for bringing that out to us. All right, let's keep it moving here. That was a good one. All right, now I gotta figure out what I'm doing again, Kaylin.
Hi, Josh. It's Natalie here from South Africa. Hope you're well. Can you give me? I can't understand that nobody can do anything about Judge Cannone in the Karen Reed trial. I'm scared. I'm really, really, really scared.
Natalie, thank you so much. First of all, let's put you on the map. Natalie from South Africa. Thank you so much. I think that's our first caller from South Africa. So appreciate you. A lot of Grizzlies from down there. So big love to the Grizzly. What are they? Grizzly pack herd? I don't think Grizzlies go in a pack or a herd. The pride. I don't know. You guys tell me. But appreciate you calling in. What can be done about Karen Reed and Judge Cannone? And I know Judge Cannone gets a lot of grief, especially from folks who are supportive of Karen Reed and feel that an injustice is being done in that case. I will say this. I hope this brings you comfort, Natalie. But first of all, in the compendium of judges, in the large spectrum of judges, of good to bad, Judge Cannone doesn't come anywhere near bad. There are plenty of awful, awful judges out there. In fact, if I'm going to talk some garbage, the judge presiding over the Wagner case, and his name escapes me right now, I think is far worse, far more involved and embroiled in this case than anybody. But has Judge Cannone made some decisions that many take issue with? Absolutely. Has she done some things that seem like she's leaning in favor of the prosecution? Absolutely. I think objectively you could look at it and go, she's probably not all that friendly to the defense, and there might be some good reasons and some bad reasons for all of that. End of the day, I have not seen Cannone do something that I felt was so egregious that would allow for another judge to kick her off. So the answer to your question is, what can be done? They can challenge her. They can challenge her by saying she is showing actual bias in this case. And that actually, would have to go in front of another judge, or perhaps even an appellate court, to decide on whether or not what she has done is so egregious to get her kicked off. Think about pulling the pin on that grenade if you're the defense, okay? If you don't win that, you go back to Judge Cannone, and now you've challenged her and called her an unfair judge. And you think the relationship is icy between those sides now? Just wait if you pull the pin on that grenade. And I don't think she has done anything for an appellate court to say yes. She has made decisions, I think, that are within her discretion, and you're going to agree with them or not agree with them. But by the way, welcome to my life. As the defense attorney, you get a lot of decisions made by judges that make you want to pull your hair out. But that falls within their discretion. And you may not. And when I was a prosecutor, I would have judges do the same thing. They would make decisions that I thought were incredibly not in line with the law. Is it within discretion? Yes, it is. What are you going to do? You're going to suck it up. You're going to tighten your belt, and you're going to carry on. And so, Natalie, I think end of the day, this is in the hands of 12 people, and it's not in the hands of the judge. And I have not seen this judge do anything that is so egregious at this point. And I hear you. and I feel you, but I think it's going to be just fine as far as Judge Cannone goes. But I appreciate you, Natalie, from South Africa, for calling in. Thank you so much for taking part in the conversation. All right, let's move it along here.
Hi, Josh. My name's Amy from Minnesota. I have a question. The Stermer case just got over, and I realized that the red towels were not able to come in because the company had closed down. They got rid of stuff after 10 years. But my question is, why couldn't they use that information from the first case and bring it into the second so that those red towels could be brought in? Thank you.
Amy from Minnesota. Let's put her on the map, first of all. Thank you so much for calling in. Oh, it looks like our first time for Minnesota as well. So thank you. What a great question. She's asking about the Linda Stermer case. This is a case that was tried just recently. She was found guilty, but it wasn't her first trial. She was actually tried 10 years before that, found guilty as well, but the Court of Appeals overturned it in the meantime because they felt that her attorneys, going back to one of our previous questions, that her attorneys had been ineffective assistance of counsel because they did not call an arson expert. And that was egregious enough in the court's view to give her a new trial. I'll be honest with you, at the time, I really had a problem with that ruling. I feel like calling an expert can depend on any number of things. Money not being the smallest part of all of that. Sometimes you have experts and they're not giving the opinion that you entirely want. Sometimes you don't have money to hire experts. It has nothing to do with the attorney making a decision, but they felt that was a big enough mistake to give her a new trial. She got a new trial and she lost. Now, because of that, there was 10 years that went by and things had happened to some of this evidence. And one of those things that had happened is a company that had done some testing on these red towels that were believed to have contained some sort of fire accelerant, had gone out of business. And what effect did that have? And when you asked me this question, Amy, it stumped me. I didn't know the answer to it. And I thought, I'm beside myself because I'm stumped by a question. I was stumped, Amy, but I was not beaten, because you know what I could do is I could phone a friend.
It's here. Josh sent me a voice message from Amy in Minnesota. Amy, you asked a question about the Linda Stermer trial, where in this recent retrial, the state was not allowed to bring in the evidence about the red towels in the laundry with the gasoline on them. And why were they not allowed to bring in the report that was evidence in the first trial, even though the underlying data was gone? Well, it has to do with Michigan law. Michigan says that if you're going to bring in that report, the defense must have the opportunity to analyze and look at and test and review with their own experts the underlying testing data. When the company went out of business and got rid of all their papers, that testing data was gone, so that report became worthless. The expert wasn't allowed to testify, and that evidence didn't come in. This is one the defense won because it just took too long to get back to a retrial.
We could not thank Scott enough for doing that for us. He's absolutely fantastic. I was stumped by this. I didn't know because I had watched this trial, but I had not watched it, every single day as closely as I know my good friend Scott from Recovery Addict had watched it. And I remember this being an issue, and I didn't remember how it entirely played out. So I called up Scott and I said, "Hey, buddy, you got a couple of minutes? What do you think? Could you record an answer to us?" And he said, "Absolutely, anything for the Courtroom Confidential community." He's a big supporter of us, and we're a big supporter of him. And so if you guys get a chance, if you haven't already subscribed to his channel, please do. Please give him a big thank you next time you're watching his channel, and thank him from the Courtroom Confidential family for helping us out. But really interesting point too, really interesting answer there is that, and by the way, I don't think that's unique entirely to Michigan where that case took place. It's this idea that if you have testing the defense should have an opportunity to do their own testing and to be able to examine the process that took part in that testing, not just the results. And because that company had shut down and there was no way to do that, the judge kept it out, which many thought might have an effect on the case, but it did not. So thank you, Amy from Minnesota, so much for the question, but a huge, huge shout out to Scott from Recovery
Hey guys,
Addict.
Recovery Addict here.
Oh,
Josh
I don't know
sent
what happened here. I don't know why that happened. I don't know why that happened. But anyhow, let me see if I'm going to. Okay, now I cleared it up. I couldn't get it to work, and now it keeps working. Big thank you to Scott from Recovery Addict for doing that for us. He's an incredible guy, and I appreciate him so much. All right, let's keep it moving.
Hey, Josh. Johnny Knoxville here in Chapel Hill, North Carolina. So I have kind of a two-part question about the Kohberger trial or case. I haven't heard anything about investigators looking for tire tracks. Given that it was winter, I would have thought that that would have been a piece of evidence that they would have tried to find driving to and from the back of the house. It just seems like something that would have been a no-brainer. Given that it was dirty, wet, and it looked like there was snow on the ground still at the time of the murders. Kind of the other part I'm wondering about is the defense going to be allowed to introduce a planting the evidence type of narrative without any kind of proof? Can they just say, oh, it was planted? Or do they have to provide some kind of, proof that was the case? Thank you. Have a great day. Great show.
Thank you so much, Johnny Knoxville from Chapel Hill, North Carolina. First of all, let's put you on the map. Appreciate you, my friend. Always good to hear from you. And a great question. And a question that had me digging around a lot too, because I feel like I remember the same thing, that they're searching for anything and everything when this investigation first started. You remember several weeks went by and they didn't have a suspect. So they're looking at everything. They're looking at fingerprints. They're looking at DNA. They're looking at video footage. They're looking at talking to people in the surrounding area. They've got suspect vehicles. So of course they're going to be looking at things like tire tracks and whatever happened with that. And here we go. Here's some photographs that we were able to find of them actually photographing these tire tracks, measuring these tire tracks. Johnny mentions, hey, it was in the snow. It was in winter, but as you can see from these photographs here, there wasn't a blanket of snow. So they were, on the street trying to they can recover tracks in mud or just left, impressions left by the rubber against the road itself. And whatever happened with that. The answer is I couldn't find out. The answer is that not much has been mentioned about these tire tracks since then. Now, that could mean one of two things. One, it could mean it went nowhere and that the tracks either had to do with any number of vehicles that have been driving in that area. And that's the problem, is that many times, even though evidence has been left behind, it is buried in all of the stuff that's not evidence. So perhaps the tire tracks from the suspect vehicle were there, and perhaps the tire tracks that they were able to find were not good enough to analyze, or they just got lost in any number of tire tracks that they found. I mean, you see in the picture there's just vehicles all over. This was a home that we know a lot of people were visiting. Many college students. Tracy Figlin points out, yes. I mean, it's needle in haystack type of stuff. But I'll say this too. This case was under a gag order for a very long time. And you remember for a long time, we didn't know much about it. And then all of a sudden, the judge changed that order and we started to get all this information about Amazon search history and about, what was happening with the DNA and about, just all of these new kind of revelations came out recently, the selfie photograph and everything else. The tire tracks could be in this stuff. And we just don't know about it. This trial, I really feel when it kicks off, we are going to learn far more about the investigation than we have learned beforehand, because we for so long we had nothing, and now that the tap has been open, it's only a drip. So who knows? The tire tracks could be a part of all of that. But Johnny Knoxville asks a second part to his question is about this planted evidence defense, and can the defense just start talking about that, or do they have to have proof of it? Well, the answer is you have to have proof of anything you want to argue, but argument is also very broad, right? So the idea of planted evidence, you may not see come up all that much in the presentation of evidence during the trial, but the idea of planted evidence may become a big part of the defense's arguments, closing arguments at the end of the case, but they have to have something to base that on. In other words, one of the objections rarely that you will see in a closing argument is facts not in evidence. The only thing that I would usually ever object to, if I ever objected at all, and I can count on one time and I don't have to use all my fingers how many times I've objected during somebody's closing arguments, but it has been when we're talking about facts not in evidence. That's what you don't want. Go ahead and argue, spin it however you want, but if you start mentioning things that are not actually in evidence, I'm going to stop you from doing it. So how do they get this planted evidence in? And I think what you will see, Johnny, is it's going to come in the form of cross-examination, and it's going to come in the form of talking about touch / transfer DNA. And it's going to come in the form of them asking questions like, because someone's DNA, touch DNA, was found on a knife sheath, you cannot tell us, Mr. Expert, that that was placed there by the person whose DNA that belongs to, correct? And that expert's going to say, correct. That is correct. It can be transferred. It can have a secondary transfer of DNA. So you can have, I could touch an object and that object could touch something else. And potentially there are instances they can prove this, that it can be transferred. I could shake someone's hand and that person could go touch something, and my DNA could make itself from my hand to their hand to that third object, right? So they're going to talk about that in their cross-examination and start to plant the seeds of quote unquote planted evidence, or other ways, what other mechanisms they have up their sleeves. But they're going to, if they want to actually make these arguments, and I think even that cross-examination that I used as an example will probably be enough for them to make those arguments about planted evidence. Sorry, I didn't see that last comment, Kaylin. Single source DNA on the snap, less likely to be transfer. Good point, Northwest. And this is all going to come out in the trial with the experts and everything. And I'm no expert on this. I've dealt with DNA all through my career, but that's another good point. Single source. What does that mean? Northwest is pointing out the idea of, in my example, if I shook somebody's hand and then that person grabbed a knife sheath, you would not expect just my transferred DNA to end up on that knife sheath. You would expect my transferred DNA plus the DNA of the person whose hand I shook to also end up on that. So the fact that it's single source, does that mean that it's more likely, the pivotal word there being likely, that it was me directly touching the knife sheath rather than some sort of transfer? Yes. But again, there's a lot of wiggle room in that word likely, and the defense will exploit that to its maximum by saying likely doesn't mean completely. Still could be possible, correct? And then, when you're the defense, sometimes you're swimming in the pool of possibilities. All right, but thank you again, Johnny Knoxville, my friend from Chapel Hill, North Carolina. All right, let's move it along here.
Josh, I asked this question once before, but I don't know if I did it properly. This is Gloria from Florida. I just had a question about whether YouTube hosts are ever opened up to charges of slander for things that they might say about a particular person that we're following in a trial, or, for instance, Stephan Sterns, who's in jail. We're listening to his jail telephone calls with his parents, and maybe some jokes are made and some comments are made. And I just wondered if there were any kind of a charge that has to be worried about. I can remember when Alec was on trial, in South Carolina, pretty soon his son Buster went into the lawyer's office to make phone calls in jail so that they wouldn't be released from FOIA requests. Okay, I just had that question. Thanks very much. I watch and listen to your podcast regularly. Thank you.
Thank you so much, Gloria, for the support. Calling in from Florida. So let's put you on the map. Gloria from Florida. Great question. And I like how you asked the question of, have YouTube hosts ever been sued for defamation? And I don't know why you're asking me that, Gloria. I don't know if I've said something that you're filing a lawsuit, but here's the answer to your question regardless. And I hear this a lot. People get steamed about defamation. They want to know how do people get away with saying certain things. I am no defamation expert as a lawyer, but I have dealt with the issue a few times because clients of mine want to know that too. They've been charged with something. Somebody's making allegations against them. They're not only insulted that they have to deal with the criminal side of things, but how do I get back at that person for coming after me and making up these lies about me? So defamation, let's first talk about it. It can come in two forms, libel and slander, depending on if it's in print or just spoken word. But it all boils down to one, a false statement purporting to be fact. So that's the first part of it. Are you saying something false and saying it in a way that is you expect it to be received as factual? In other words, you're not in an SNL skit. This isn't some sort of satire. You're actually telling people what you believe to be fact, but it's false. It's been communicated to a third party. So on YouTube, in print, in a newspaper, it's not just not being exposed to the world. Then some sort of negligence. So you're saying something and there was some sort of negligent behavior in not realizing the falseness of what you were saying. And then damages. And this is really kind of the pivotal thing when it comes down to a lot of these, is how do you prove damages? How do you prove that somebody's saying something awful about you? It may have hurt you. It may have hurt your feelings, but how do we attach a number to that? And you don't just go $5 million because that's how much it bothers me. No. Where did you lose? Did you lose income? Did you lose potential future income? Did you lose reputational harm? That can cost some money. What is that valued at? But just saying, I want to punish that person, I want to sue them for $20 million for the awful, awful things they said, not going to fly. You've got to be able to show actual damages, actual loss to a judge. And if you don't have it, that could alone get your case kicked out. The biggest case on this, and we've heard, if you follow this at all, is New York Times versus Sullivan from 1964. And this dealt with public officials. And the idea that when you're talking about a public official, somebody who's in the news, we're going to even apply a higher standard. Because if you're a public official, if you're somebody who's a public persona, there's kind of more exposure that you're just naturally going to receive. So it's not going to just be negligence. We're going to say that it's with knowledge that the statement was false, with reckless disregard as to whether or not it was false. So it's not just a false statement now and negligence. It's now reckless disregard to a clear and convincing standard. Here's the defenses to defamation. And again, why you don't see these cases all that often. One, and this harkens back to Johnny Depp v. Amber Heard. If you remember that, a lot of this case hinged on these issues. First of all, truth. You can't slander somebody if you're telling the truth. So that's why the Johnny Depp case came down to, if she's saying she's the victim of domestic violence, can she prove domestic violence would be the defense to slander, to defamation. You actually did do the thing I'm saying you did. Statements of opinion. In other words, much of what YouTube is about is giving your opinion on something, and your opinion is different from saying something's actually true. And then this is the big catch-all, statements of fair criticism on matters of public interest. So Karen Reed may not be a public official, but she is a matter of public interest. All of these cases are matters of public interest. So fair criticism on matters of public interest will not ding you for defamation. You have to show actual malice. Now, do I feel some people on the internet still qualify for that. I absolutely do. I don't think I'm one of them, so don't sue me, Gloria, but great question, and I appreciate you asking it, and I hope that kind of clears up some questions that a lot of people had about defamation. But thank you for that, Gloria. All right, let's move it along here. Where do we land next? Where does our fueled up plane land next?
Hi, I'm Valerie in Northwest Indiana. I just listened for the first time and loved your show. The Russell Brand cases prompted me to ask you, how can you defend yourself or provide an alibi after decades, especially in the E. Jean Carroll case, where she couldn't provide a year, much less a day, of the incident? If you've already addressed this somewhere else, please note so I can find your answer. Thank you.
Thank you so much, Valerie, calling in from Indiana. Let's put you on the map. You ask an incredible question as well. This is about Russell Brand. If you know, Russell Brand was recently indicted out of the United Kingdom for crimes related to sexual assault. And these allegations are many years old, some of them 10 plus years old. And it brings up this interesting tension in the law. Many times with these cases that are very, very serious, and when you're dealing with sexual assault, it is serious. The statute of limitations, and I'm speaking more from kind of the American perspective, but the statute of limitations will be very long. So you can reach back decades to charge someone for these types of crimes. But in doing that, are you also putting the defendant at a huge disadvantage to try to recreate evidence from decades ago? How does Russell Brand go back decades ago and find audio tape or text messages or videotape or witnesses to try to corroborate his events, to try to corroborate an alibi, to try to corroborate his defense? It's incredibly difficult. And the answer to all of that is, one, that's the way it works, Valerie, but two, that's why the burden's on the prosecution. As difficult it is for the defense to mount a defense, it's also difficult for the prosecution to put together a prosecution on cases these old. Because for the same reasons, what corroborating evidence do they have of these allegations? What support do they have? Do they have videotape? Do they have hospital examinations? Likely no. Is there physical evidence that still exists? Likely no. Is there anything to corroborate these allegations? So you're put in these positions where it's a he said, she said, and now it's decades old. So why are these cases even brought? What evidence do they have to even support this, to bring it? Well, you notice in a case like this, it's usually never one victim, and it's usually more than one. And that's when you start to get into this idea of cross corroboration between people who don't know each other, people who've never met, people who have no reason to support each other, are giving remarkably similar stories of things that took place to them. So it is it's a two-edged sword. You've got cases where you want justice done for victims, no matter how long ago it took place. I agree with that. And at the same time, I agree that it can be very difficult for somebody like this Russell Brand to defend himself from allegations from decades ago. Learning Curve says, wouldn't there be a lot of hearsay in that trial because of lack of physical evidence? Well, not just hearsay, but there's going to just be a lot of credibility being placed on the victims themselves. In other words, what I mean by that is a lot of the case is going to come down to the believability of the victim. And if there should be some supporting evidence, some corroborating evidence, but it's going to come down to the jurors. Do they believe this person? Are they putting together enough of a memory with enough specifics that can be supported and corroborated to get me past the point of reasonable doubt? That's going to be a very difficult case from the prosecution, and also a difficult case for Russell Brand and his team to try to impeach. So we will continue to follow that case, but I appreciate you, Valerie from Indiana, for bringing that one up into our attention again. All right. Let's keep it rolling here. Oh, Crazy Mom RN, thank you so much for gifting the memberships. You're fantastic, and I appreciate your support. Hold on.
Hi, Josh. Redondo Beach here. Question for you. As a defense attorney, how can you get a client if you see a plea agreement, whether you know or not they're guilty, you see that as the best road, whether or not to put families or victims or whatever through a trial, make them go through that? How do you encourage a plea deal, or are you not able to even weigh in on that? Can you just say, the state is presenting this, or can you suggest, hey, I think we should get a plea deal? How do you handle that with a defendant?
Hello, Redondo Beach, and I'm guessing you're from Redondo Beach. So thank you so much for calling in. I always appreciate hearing from you and seeing your comments. And great question too. How involved are defense attorneys in the not only plea negotiations, but also trying to convince their client of a plea? The answer is very, very involved. First of all, the attorney is doing all the plea negotiations. So they're the ones speaking to the DA, trying to convince them of their side, trying to, find some sort of middle ground, some sort of way where the prosecution can feel like they got justice, and the defense attorney can convince his client to take it and move on with their life. It's not like Law and Order. Sorry to crush all of you, but there is never this both sides sitting at the same table and you're sitting next to your client's barking things at the prosecutor and the prosecutor's barking things at them. I've never had that in my entire life. It is usually conversations between me and the prosecutor taking place privately, either in court or in their office, and then I go back and talk to my client. And what do I do if I feel like they should take it? So here's a reality of the system. Many times people are pleading to things that they feel like they may not have done, or maybe they feel like they did something wrong, but not exactly what they're accused of. But they are making a calculation based upon how bad could this get for me? And I know that might sound awful and cynical, but it really does come down to that. Many times people are going, listen, I don't think I did. I'm guilty of what exactly I'm accused of, but I'm going to take advantage of this plea deal because it prevents me from going to prison for a very long time, because I know if I do go to trial, it looks so bad, I could end up in prison for the rest of my life. That's how it works a lot of times. And they're, in fact, written into the plea deals. You ask them the question, are you accepting this because you feel it is in your best interest to do so? There is specific case law on the idea that you can take a plea because it's in your best interest and you're not entirely admitting to guilt. And the case is, the name of that is escaping me right now. Oh, I'll get it. It'll hit me out of nowhere and I'll scream out the name. But there is the idea that you can plead and you're saying, I didn't do what you're saying I did, but I realize how bad this looks, and I realize how bad it could get for me if I don't accept this plea. And I will have extensive conversations with my clients about, listen, dude, this is how bad things could get for you. This is how bad it looks for you. This is the evidence they're going to put on, and we don't have much to combat it. And I may believe you. I may understand what you're saying. I may sympathize with you, but my job is to keep you out of prison for the rest of your life. And what they're offering is an avenue to do that. So we need to take advantage of it. And other times I go, listen, it's up to you. Yes or no, do you want this? Here's what they're offering. This is your decision to make. You need to accept this. Alford plea. That is one of, Alford is one of the cases. There's another case in California. But yes, Alford, you guys got the idea where I'm going with this whole thing. Yeah. and I will sit down with them and say, listen, dude, it comes down to what you want. Because what I also don't want is them feeling like I've pressured them so much to take a plea that they later on take it and then blame me for it, which ends up happening anyways, because nobody's happy at the end of the day with these things, and they're always angry at their lawyer. But it's a great question, Redondo Beach, and I appreciate you asking it, but it kind of gives you an understanding of, kind of the dirty back dealings, or that's probably not the right way of putting it, but it's kind of the behind the scenes stuff that it's not always clear cut. Thank you so much, Johnny, for gifting that membership. Appreciate you and your support. All right. Yes, Annalie Fitch, I appreciate you saying that. They are great viewer questions. Let's keep them going here, shall we? Where are we at?
Hi, Josh. This is Maureen from California. I have a question, but first a comment. I was watching one of your bonus videos that you recorded in your car, and you were wearing your LA Dodgers baseball cap. And I wanted to tell you about my favorite baseball memory, which may make you a little bit jealous, but it will definitely tell you how very old I am. When I was in 6th grade, I attended a Sunday doubleheader game with the Dodgers at Chavez Ravine. And we were fortunate enough to have seats in the second row behind the Dodger dugout. So they were terrific seats. And I was thrilled because I was going to be watching my baseball hero pitch the first game. And that hero is still a hero, and it's Sandy Koufax. I don't remember who we played or whether we won that game, but I loved watching Sandy pitch. And then in the interval between the two games, they had a ceremony where they awarded him the Cy Young Award for pitching. And that to this day remains my favorite baseball memory. And now for my question, but I'm going to run out of time, so I'm going to do it in the next recording. This is Maureen with part 2, the question. It concerns a case that is not a case, but I'm wondering if it should be a case in the interest of justice. And this concerns the death of the actress Natalie Wood, who drowned in the 80s, I believe, off of the island of Catalina. At the time, the story was that everybody had been drinking, they were drunk. There was some sort of an argument between Natalie Wood and her husband, Robert Wagner, and she became angry at some point and decided to climb down the side of the boat into the dinghy and make her way towards shore. The information has come out since then that there was more to the story. Principally, I think it's the boat's captain who said that there was an argument and that probably Robert Wagner had more to do with Natalie's death than he had told, and that the boat captain had been complicit in not telling the complete story. I'm just wondering if charges should be filed in the interest of justice, even though this is an old case. Does Natalie Wood deserve justice? Thanks, Josh.
Thank you so much, Maureen from Monterey, California. Let's put you on the map first and foremost. I appreciate you calling in and giving some love to Monterey, California, and some love to Sandy Koufax and to the Dodgers. And if you don't know already, I'm a huge Dodger fan, and yes, going to Dodger games is a big part of my childhood, and up until we started having little ones, it was a big part of my life. Tiffany and I used to live very near Dodger Stadium. Hey, hello, Gisela. Good to see you. Hello, everybody. Lurking while working. I love it. Well, thank you for saying hello. Before Tiffany and I started having little ones, we used to live very near the stadium, and one of our favorite things to do was in the morning, I would say, do we have anything going on tonight? And she'd say no. And I'd say, well, Clayton Kershaw's pitching. What do you think about going to the game? And you could just go on StubHub or whatever and find tickets really cheap. And I'd go to work and I'd come pick her up after work, and we'd head over to the game and watch a few innings and have a hot dog and a couple of beers and come home. And it was a very fun part of life. And I can't wait till the little ones are old enough that I can take them and they can scream and say they're bored and they want more popcorn and when are we leaving? And then we'll watch 3 innings and come home. But anyhow, Sandy Koufax, wonderful, one of the best pitchers in the game has ever had. But to your question, Maureen, about Natalie Wood, this is one of those cases that goes into the Hall of Fame of unsolved, kind of controversial Hollywood true crime cases. Natalie Wood, Robert Wagner, and Christopher Walken. And Natalie Wood and Robert Wagner were, I don't think they were married, but I think they were involved with each other at the time. And they're on a boat in November 28th and 29th of 1981. They are working on the movie Brainstorm at the time, and that they were filming that together. Oh, there you go. Look at Kaylin, always just finding the good stuff. So they're working on this movie, and in the middle of filming it or soon after filming it, they're out on a boat. The 3 of them, along with the captain, in the waters here in Southern California near Catalina Island. She somehow goes overboard, and her body is later recovered on November 29th, and she is drowned to death. And at the time, the coroner in 1981 calls her death an accidental drowning. And in the investigation, this is what Maureen points out, there has been some change. So at first, Wagner said there was absolutely no issue between the 2 of them. The boat captain said there was no issues on board. Later on, the boat captain changes his story and says, yes, they had actually been arguing. There was perhaps some jealousy between Wagner and Christopher Walken, and whether or not Natalie Wood was giving a little bit too much attention to Christopher Walken. And there's Christopher Walken now. He looked much different back in 1981, so you could understand the jealousy. But then to add further to all of this, and by the way, when the autopsy was performed, to add to this, she had a 0.14 BAC. There were painkillers and motion sickness pills in her system, and they believe that she just lost balance. Whatever happened, she fell into the water. She was wearing clothing that soaked up the water and became very heavy, and she tragically drowned. However, in 2012, the LA County Coroner's Office takes another look at this for some reason and changes the opinion to drowning. This is a quote, drowning and other undetermined factors. And it may have been that there was other injuries found on her that they believe could have taken place prior to her drowning. In 2018, the last that I could find any official police comment on this, they said that Wagner is still a person of interest. And so Maureen's question is, could this case ever be charged? The answer is sure. The statute of limitations on murder there is none. It's open-ended. They could charge this, it doesn't matter how many years later. And 1981 is not that long ago that they wouldn't charge it. Problem is, if they want to, they're running out of time. Robert Wagner is now 95 years old. So I doubt that there has been any new evidence that would change this in all of that time, unless Wagner comes forward and says, I did it and I want to clear my conscience before I meet my maker, or Christopher Walken produces some videotape or something like that. Yeah, LA, he is. I had to look it up myself. So, this case is still a quote unquote open cold case, and still a case where it has not been entirely closed as to lacking any suspicion. But really excellent question, Maureen, and I appreciate you asking it. I love this. Who thought we would be talking about Sandy Koufax, Natalie Wood, Alec Murdoch, Bryan Kohberger, Karen Reed, all in the same conversation? I love it. All right, let's move it along here.
Hi, Josh, and hello to everyone who makes Courtroom Confidential so amazing. This is Anne, also known as Objection Cake around YouTube, and I'm calling from Langley, BC, Canada. By the way, if it sounds like I'm reading, it's because I am, because I was nervous to call. My question for you is, if you had to pick one case between Lori Vallow, Karen Reed, or Linda Stermer, which case would you pick, and would you prosecute or defend, and why? Yeah, that's it. Thank you so much. Love Sunday Fun Day, and big shout out to all the Grizzlies watching.
Thank you so much, Anne / Objection Cake from Langley, BC, Canada. Let's throw you on the map. Thank you. Appreciate your support and always appreciate seeing your comments. You never cease to call me out if you think I need calling out. So I appreciate that, Objection Cake. And it's a great question. Who would I either prosecute or represent between Lori Vallow, Karen Reed, and Linda Stermer? There they are. I'm going to say I would like to prosecute Linda Stermer. And the reason for that is I just think it's the more interesting case factually. I just think that it's, you're talking about a case that's kind of gone cold. You're talking about a case where there's, interesting elements of both arson and blunt force trauma and the car being involved. And then you've got the family dynamic. It just seems like if you're going to give yourself a challenge, the Linda Stermer case might give you a challenge. Karen Reed, I don't want to have anything. I don't want to come anywhere near that thing because it just looks like anybody who does get near it is somewhere someone on the internet is coming after you. And Lori Vallow, that to me was a case where they're already playing with house money. So I feel like the Linda Stermer case is a little bit more interesting and a little more high stakes. And I like these kind of cold cases. When I was a prosecutor, I didn't get to do many of them, but the ones that I did, I just found to be far more fulfilling and fascinating. So, Anne, Objection Cake from Langley, British Columbia, Canada. Thank you so much for calling in. Always appreciate hearing from you. All right. You guys loving this? I'm loving this.
Hi, Josh. It's Maureen from Monterey, California again. I have a question. I'm watching the Lori Vallow trial, and I'm wondering if I don't have a good understanding of what is leading in questioning. It seems to me that almost all of the questions that the prosecution is asking the witnesses are leading questions, where she will say, and so you went to such and such a place because you found that blah, 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 blah. Is that correct? Rather than where did you go and what did you find? And to me, it seems like that's leading. Maybe I'm wrong, but my feeling is that because Lori's not an attorney, if they are leading, she's not objecting to questions that she should be objecting to. And it is not the judge's job to make those objections for her. So that means the prosecution's getting away with things she wouldn't normally get away with. Is this correct? Or am I completely off base? Thanks a lot, Josh. Bye-bye.
Thank you so much, Maureen, from Monterey, California. You are correct. Yes, the prosecution, those are leading questions, and the prosecution was getting away with it. A leading question is anything that suggests the answer. So you're right. The questions that a prosecutor should be asking are things like, what happened next? Where did you go next? What did you do next? What did that person say? Open-ended questions that allow the witness to be the one in charge, to be leading the narrative rather than you leading them through it. rather than you suggesting it? Isn't it true that you then walked to McDonald's and that asked for yes or no? And that's the kind of things that you see on cross. The other part of that, though, is, yeah, if there's no objection, then you kind of get away with it. And as both the defense attorney and a prosecutor, I've done that. You know, if I'm going to ask questions that may be helpful to the witness to kind of get them back on track, because sometimes that happens with witnesses. And if there's no objection, there's no objection. It is not the judge's job to be making the objections, but many judges will. Many judges will make their own objections. That's leading. Move on, counsel. That's irrelevant, counsel. Move on. But for the most part, most judges will let the attorneys handle it as they will. I will say this too. Now, this wasn't happening with Lori Vallow, but I will say this. I am the type of an attorney who I don't make all that many objections, certainly not on these technical things, and certainly not on situations where I'm not all that afraid of the answer. Now, there's parts where I know the question is asking for something that will lead to evidence that I don't want in, but many times I'll just let them answer, because sometimes you get some good stuff. Sometimes that's where the magic happens, is in these questions that you don't object to, and all of a sudden the witness is saying something fantastic that the prosecutor never saw coming. Let it happen. One last point on direct and cross, just for your guys, if you're taking notes, is that there is a rare situation where on direct, you can ask leading questions. And that is where, and you may have heard this before, this term, where they say that they would like to take the witness as a hostile witness. In California, it's a case that outlines that as People versus Green. So you may hear attorneys in California say, Your Honor, I'd like to green this witness, or I'd like to proceed pursuant to People versus Green, which is basically meaning that this witness is not cooperative. This witness is either not telling the truth, not testifying to what they had testified to before, has a motivation to not be cooperative, even though they are my witness on direct. And I'd like to therefore cross-examine them, because they're answering things differently. And I want to be able to impeach them. So I need to be able to cross-examine them and ask them leading questions. So thank you so much again, Maureen, for the question. Always appreciate to kind of provide some insights on terms that we hear all the time, but may not fully understand.
Hi, Josh. This is Michaela calling from Oak Grove, Minnesota. Love listening to your channel and your conversations. My question has to do about just speaking to how do they decide what prior bad acts come into court cases. So for example, with the Lori Vallow trial going on right now, as a juror, I would be really upset if I did not know this whole time that she had been convicted of killing Tylee and JJ. And I understand that they want to try her, based on the strength of evidence in Charles's case. However, it seems to me like it's kind of the continuation of the same act. It's kind of part of the same thing, if you will. So how is it decided that they're not going to allow that kind of evidence in? Thank you.
Michaela from Oak Grove, Minnesota. What a great question. I love this question. I really, prior bad acts is one of the part of criminal law that I really dig into, because it can be incredibly powerful and it's often misunderstood. Crazy Mom RN says, great question. I agree. The first place to start from is to realize that a big no-no, part of our criminal justice system, is we do not try people for who they are. We try them for what they have done. These are not cases about character. And so bringing in things that are uncharged, prior bad acts, we need to be really careful about, because we don't want the jury saying, you know what, I don't know if this person did the thing that they're charged with, but I know this person's a complete dirtbag, and they're likely the type of person to commit this crime. Therefore, I'm going to find them guilty of this crime. That's the thing that we want to avoid at all costs. Okay. So in California, we have what's called Evidence Code 1101. This is based off of kind of the federal rules of evidence. A lot of different states use similar rules. So I'm just going to go off of what we have here in California. And we could talk about this for hours, and I'm going to do it as quickly as I can so we don't get lost in the weeds. But 1101 provides that, except as provided in other sections, evidence, so unless there's an exception to this, the general rule is that evidence of a person's character or a trait of his or her character, whether in the form of opinion, evidence of reputation, or evidence of specific instances, so prior bad acts of their conduct, is inadmissible when offered to prove his or her conduct on a specified occasion. So that's exactly what I was saying. We don't want to bring in prior things they've done to try to prove that they did the thing that they're charged for, okay? We don't talk about people's character. We don't talk about whether or not they have an inclination or they're predisposed to be a bad person. We talk about whether or not we have evidence, did they commit this crime? However, there's an exception to that. Part B, so you'll hear this in California, 1101B evidence is what they refer to as prior bad acts evidence. Nothing in this section prohibits the admission of evidence that a person committed a crime, civil wrong, or other act when relevant to prove some fact such as, so if you're not using it for character, but you're using it to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or accident. Other than this, in other words, things other than his or her disposition to commit such an act. So if you're bringing it in not for their character, not to show their disposition, not to show that just they're a bad person, or perhaps you're bringing it in to show planning, knowledge, preparation, identity, things like this person committed this type of crime in such the exact same manner. They always wore a black fedora. They always stabbed the person with a knife. They always got away in a blue vehicle. They always said these certain words. All of this kind of stuff shows that we're not using this to show this person's a bad person. We're using this to show a common plan or scheme. We're using this to show perhaps motive for why they committed this crime. Any of these other things make it acceptable. So in the question of Lori Vallow, the judge decided that those prior crimes did not show some sort of common plan or scheme. Now, I realize that you're saying, well, wasn't it all part of the same plan or scheme? The judge felt that it wasn't. And oftentimes you will see this happen when it is something horrendous that is the prior bad act. When it is a prior murder, a murder of your children, that we're so concerned about jurors hearing that and being so inflamed that they're going to say, this lady killed her kids. I don't really care about that's the tail wagging the dog as far as I'm concerned when it comes to did she take part in this murder of her prior husband? She's already a child killer. Let's go ahead and convict her for this as well. And I don't really need to hear all that much evidence. So that's why you see judges avoid that. They're very careful, and they should be, because this, by the way, is what causes the most problems on appeal. Harvey Weinstein, ever heard of him, is back on trial in New York because of an abuse of this type of law right here. The Court of Appeals in New York felt that they got too much of this prior bad acts evidence in that was unrelated, didn't prove something other than character, and therefore he got a new trial. So that's exactly why they treat this so carefully. One last thing on this. If you take the stand, it kind of changes everything, because the last section to this law is that nothing in this section affects the admissibility of evidence offered to support or attack the credibility of a witness. So had Lori testified, the murder of these two beautiful children likely would have come in. Joe Schmo. Hey, Joe Schmo says Judge Bresky probably believed that the court he could err on the side of caution. I agree with you, and protect her defendant's rights without all of the other stuff. And he was right. Juror 15 may be a problem, though. Oh, boy. Juror 15. Juror 15. That's getting me on a tangent that I don't have time for now, but I appreciate you, Joe Schmo, and bringing it up, and we'll probably be talking about it again soon. All right. Let's move it along here. Great question, Michaela.
Hi, Josh and the Courtroom Confidential crew. This is Jen M. calling for the second week in a row. My question this week is about Lori Vallow. I'm shocked at how much the prosecution is leading with their questions, and of course, she is not objecting. Could this become an issue with an appeal, even if she chose to represent herself? Thanks.
Jen M, you think very similarly to who else was it? Oh, Maureen. Yeah, great question. First of all, let's put you on the map. Fall River, Massachusetts. Appreciate you for calling in. Here's the thing I'll add on these leading questions things too. Leading questions are kind of sometimes not the biggest worry for defense attorneys, because many times you know the story, you're just trying to move it along, right? So yeah, if the prosecutor wants to lead a little bit to just get the witness over this obstacle or hump in their testimony and get us back on track, fine. In fact, judges will sometimes say that. I'm going to allow it. I'm going to allow some of this leading just to get this witness who doesn't seem to, is lost in the woods back on track so that we can get this trial underway. And because of that, it's very discretionary and likely will not lead to any kind of issue on appeal. But I could tell that it bothered you guys. But the prosecutor, good on her for getting away with what she could get away with, and it's not going to really create any kind of issue. And there she is, and I forgot her name, but she did a admirable job. CB Kansas, thank you so much, says, can you explain why defense attorneys can bring up prior bad acts of witnesses but not the defendant? Well, the answer is, when you testify as a witness, you're talking about the prior bad acts of a witness. When you testify as a witness, your credibility is always at issue. So if you have committed a crime in the past, that is something the jury should know. A crime of moral turpitude, that is something the jury should know. Your credibility is at issue when you take the stand. The character of the defendant, however, is not at issue when you're talking about whether or not somebody committed a crime. And that may sound like an outrageous statement, but it's absolutely true. What is at issue is whether or not they committed a crime beyond a reasonable doubt, not whether or not they're a horrible, bad person that we don't like. But you take the stand, people are going to get into your business, is the official Supreme Court ruling on that. Thank you so much. All right, let's move it along here.
Hi, Josh and Courtroom Confidential crew. This is Tracy from Orlando. I sent you an email with an article to go with this voicemail about touch or transfer DNA. And as I was reading it, I was very worried about the fact that a bad police investigation or tunnel vision could essentially arrest and convict the wrong person, because DNA is not really as ironclad as we all think it is. As I'm walking around the world shedding my DNA everywhere, I was just wondering how you would think that, I know with Karen Reed, the touch DNA on the car and the knife sheet for Kohberger, but what happens when someone is truly innocent and this is innocent transfer? Just wanted to find out what your thoughts were on that. Thanks, guys.
Thank you so much, Tracy. Let's put you on the map. Tracy from Orlando, Florida. Great question. Talking about Bryan Kohberger. You also mentioned Karen Reed, but Bryan Kohberger, I think, is where it's going to become the biggest issue about touch or transfer DNA, and will this be, used inappropriately or given too much weight by the jurors? Here's the thing: DNA, like much evidence, is circumstantial evidence. Okay, all it means, think about it. You find a fingerprint, okay, on a window. What does that mean? That means that you believe circumstantially that someone touched that window at some point in time, okay? That doesn't mean necessarily they were there when the burglary, the home invasion took place. That just means at some point in time, you believe that person touched it. Now, you don't have direct evidence of that. Nobody saw that person touch the window, but the fingerprint is circumstantial evidence that at one point in time, they touched that window. Same thing with DNA. When you're dealing with hair, or let's talk about something like blood. When you're dealing with blood, It's circumstantial evidence that that person likely bled in that area to have left that blood droplet. Same thing with saliva. Hair is a little bit different. Hair is much more like touch or transfer DNA because hair can be moved from one location to the other. My hair can get onto somebody else, and that somebody else can go into a room and my hair could fall off. And now you're not saying that I was ever in that room. All you're able to prove is that my hair was in that room. How did it get there? It's all circumstantial evidence. Doesn't mean it's not powerful evidence, but it is circumstantial. Same thing with touch DNA. We're not talking about bodily fluid or other genetic material. We're talking about like blood, saliva, or hairs. We're talking about shed skin cells. And so therefore, there's two different ways that, well, more than two, but two different kind of categories of how that DNA could get there. Either direct transfer, meaning somebody directly touched that knife sheath, or secondary transfer, meaning that the DNA from the suspect touched an object or person, and that object or person touched that final object from where it was recovered from, in this case, the knife sheath. The answer to all of that is this will be explored in the case. This will be explored through cross-examination. This will be explored through the presentation of the case, and it will be assigned whatever weight that the jury feels is appropriate to it. This whole case, a large part of this case does have to do with that DNA, but the whole case does not hinge on that, because it just so happens that this person also cannot provide an alibi for where they were at that time. Their phone was allegedly turned off. And everything I'm about to say is allegedly, because we haven't seen one piece of evidence actually presented at trial, but their phone was allegedly turned off. They allegedly drive a vehicle similar to the suspect vehicle. All of these other things are, again, circumstantial evidence to bolster as to why the police believe, the prosecution believes, that that knife sheath, that the DNA found on that knife sheath is direct transfer, and that that knife sheath was left there by the suspect. But again, it all comes down to circumstantial evidence and argument. So, Tracy, while I understand your concern, I don't think that that will not be fully explored. And you're right. Are there instances where there has been transfer of DNA and you've got people maybe falsely accused? Sure. But is that incredibly common? No. And is it a cause for concern in this case? It's a cause for the defense to make arguments. This is a great explanation of how things consider a direct forensic evidence is actually circumstantial evidence. It is. It absolutely is. And I'm glad that Kaylin put this up here, because I always want to remember when we're talking about these cases to remember the victims. We're talking about Ethan Chapin, Kaylee Gonzalez, Xana Kernodle, and Madison Mogan. Thank you guys for asking the question. But yeah, this is going to be a fascinating case. That touch DNA, transfer DNA, whatever you want to call it, is a central part of that case. But it's not the only part. And you know, it just so happens that person whose DNA was found there, it would be pretty remarkable if that person had their DNA secondarily transferred there, and they also happened to purchase a knife and a sheath months prior. They happen to have no alibi. They happen to drive a similar vehicle. A lot of coincidences that add up to circumstantial evidence of this person's involvement, and we'll see how it all plays out. And I'll leave it there for now. But thank you again, Tracy from Orlando, Florida. All right.
Hi, Josh. This is Natasha from North Carolina, and I have a question about the Lori Vallow Daybell trials. I've heard a couple people this past week say that if she's found guilty of conspiring to kill her husband, Charles, that they probably won't go forward with the Brandon Boudreaux attempted murder trial. I was just wondering your opinion on that. And then also, how much would the prosecution take into account the victim? Like, if, you know, what Brandon Boudreaux thinks? And then also, what do you think the resolution will be if they don't try her? Will they offer her a deal? Will they drop it? What do you think will happen? So thanks for your answer in advance, and thank you to everyone. Bye.
Thank you so much, Natasha. Let's put you on the map from North Carolina. Appreciate you calling in. Great question about Lori Vallow. I hear this a lot. People are really concerned with, kind of efficiency, and why are we trying these cases against people who are already convicted? And now that she's been convicted in Idaho and again in Arizona, are we going to go after her for another time for the attempted murder of Brandon Boudreaux? To the second part of your question, will they take into consideration his thoughts, Brandon Boudreaux's? Yeah, they will. If he's like, listen, I want my day in court as well, that'll play a role. If he says, listen, I don't care what you do, take a plea, don't do the trial, that'll play a role as well. It's not going to dictate what they do, but it will play a role in their decision making. Are they going to offer her a plea deal? I think so. I think they probably will. Something, that will likely be even concurrent time. They've got her for life. They don't need to add life plus whatever the exposure is on an attempted murder. They realize that as well. I have heard that they are proceeding on that trial. I've heard, in fact, they're not going to sentence her until they proceed on this trial or resolve this trial. So, end of the day, I do not get as bothered by this. People saying, what are we doing this for? Why are we continuing to put on these trials? Because in my view, the prosecutors are sitting there, and I'd rather them doing trials than not doing trials. It's not like it costs the taxpayer any more money to do this. But I do realize you're putting victims and everybody else through the stress of putting on a trial. But I think that every victim deserves their day in court. But I kind of imagine this will probably resolve without a trial. Leslie says exactly the opposite of me. She won't take a plea, enjoys the spotlight, and thinks she has done nothing wrong. Maybe you're right. Maybe we'll see her back in court again in the Brandon Boudreaux trial. Because end of the day, it doesn't matter what they offer her. She's got to take it. So she says she will not take a plea. So there's to my question, Northwest. Thank you. All right. Great question, though. Natasha from North Carolina. Let's keep it rolling here. Where are we going next?
Hi, Josh. This is Gloria from Florida. I was just wondering on these civil judgments, are people required to sell everything they own in order to pay the judgment? I mean, do they sell their house that's humble, or they sell the only car they have? I know when O.J. Simpson had to sell some of his possessions to pay that judgment. He had some to sell. I think he sold his large home, but that might have been a palace. What happens with the Landrys in Florida? If Gabby Petito's family got a judgment that was undisclosed, let's say it's many $1 million, how much of everything do they sell? And then do they go bankrupt, or does it just, the judgment just stays on the books? And if they ever come into any assets, that will go toward the judgment. Okay, I was just wondering. Thanks. Love your shows. Bye-bye.
Thank you so much, Gloria. Let's put you on the map. Gloria from Florida. Great question. So she's asking about what happens in these civil cases. O.J. Simpson got a huge civil ruling. He was found not guilty criminally, but he was found liable civilly. So they got a huge ruling against him, several $1 million. And the Petito family is suing the Laundrie family over the death of Gabby Petito. If they get a big judgment in that, and I think they've actually settled that case. Correct me if I'm wrong. How do they actually collect on this? And does that entail people selling everything? The answer is it's treated like any other legally enforceable debt. You owe a credit card company. That's a legally enforceable debt. How are you going to handle it? Well, you could sell everything. You could negotiate with the whoever holds that debt. By the way, these debts can be transferred as well. Sometimes you get a judgment and it's worth X amount of dollars. And instead of waiting around to collect that, you sell that to a collection agency for pennies on the dollar so that you get your money up front. And then they try to collect that debt. It's like any other debt. Ultimately, yeah, they can go about trying to seize property and garnish wages. But usually the way this ends up before it goes to any of that is it will go through a bankruptcy court. And the person, if they do not have the money to pay, they will declare bankruptcy. It will go through bankruptcy and be treated like any other debt. It gets priority over other debts, but it will be treated like any other debt. Can they file bankruptcy to avoid judgment? Well, they're not filing it to avoid, they're filing it to figure out how a bankruptcy court will then decide the what assets need to be liquidated and how they will be liquidated and how these people will be made whole. Just because you declared bankruptcy doesn't necessarily mean that your debts go away. And in fact, some of them survive bankruptcy protection, including debts like this. And the types of things that survive bankruptcy protection, by the way, are exactly what you see in a case like the Gabby Petito case or the O.J. Simpson case, which is where it's in an intentional tort. Many torts are based upon, torts meaning civil cases, are based upon negligence, but there are some intentional torts. And that's why in this case, you've seen that they've charged the Laundries with intentional infliction of emotional distress. That is an intentional tort, and that intentional tort will survive bankruptcy and will be a debt that even if they declare bankruptcy, they're going to have to pay back. And the bankruptcy courts will decide how that is all done. So great question, Gloria. We should have like an asterisk disclaimer icon, Kaylin. Maybe we can work on that where I say, I am not a bankruptcy lawyer. So please don't take this as legal advice. But that is my limited understanding, having dealt with this stuff a little bit in the past. And I also called my brother, but he wouldn't put together a video. So there you go. Thank you so much, Gloria from Florida, for asking that question. All right. We're getting through this. We're moving at a quick clip to get through as many of these questions. And I will say this up front. You guys have left questions. I'm doing my best to answer every one of them. And I know that even some of you left some of them within hours before us starting this. And I'm just sorry. At a certain point, I had to stop. But we will get to those next week if we possibly can. All right. Where are we at here?
Hi, Josh and Courtroom Confidential. This is Kathy Davidson calling from Yakima, Washington. We're the home of the apples and the hops. That's what we're known for here. Today, I don't have a question on any of the trials, but a few weeks ago, you were talking about revamping your background when you're doing your shows. And I have to admit that I always look at everyone's backgrounds and I try to peek and see what books they're reading or what items they have on their bookshelves. So, one, I'm just curious. I know you just have 2 or 3 books up there. I'm just curious what they are. And 2, if you could tell us how you're going to redecorate your background. If you're going to add more books, a bookshelf, a mural. That was it. Hope you guys had a great week, and I will see you on Fun Day Sunday.
Thank you so much, Kathy from Yakima, Washington. Let's put Yakima on the map there. I don't know what we're going to do. We're struggling with this one. We want to change it up because we feel like it's a little bit plain. We want to add some depth. We want to add some color. We want to make it cool. You know what would be great is if you guys know other creators on YouTube that you like their background, let us know. And that might give us some inspiration. But it's a struggle, but we're going to be figuring it out here soon. It's a team effort and we're trying to figure it out. Yeah. We need a background refresh. We've grown tired. My poor little plant there hasn't been watered in years, so we need to figure something else out. And then to your question about the books, I don't know if you can hear this with me turning my head. Going from left to right, it is Truman Capote's In Cold Blood, which was kind of like the beginning of the true crime nonfiction novel. Then it is Bugliosi's Helter Skelter, which is all about the Charlie Manson case, which is an incredible book written from the perspective of a prosecutor, which was an inspiration for me. And then it's Harper Lee's To Kill a Mockingbird. So it kind of all kept it in the theme, kept it in the family of true crime and prosecutors and mysteries. But thank you for those questions. And also Tio Toys, Phil's car. I think I showed this to you guys before. He was so generous to send that to us. So that's got a little place of honor up there on the shelf as well. But yeah, let us know, guys. If you got great ideas for backgrounds, or you know other creators that you like their background, then send it to us and we will confidential neon sign. That's a great suggestion too. We're working on anything you feel is good. She said, Marta says, add Matt Murphy's book, The Book of Murder. I do have that book here. Maybe we will do like a big bookshelf with a bunch of stuff on it. So thank you guys for the suggestions. Let's move it along here. I'm losing track. Where are we at? Oh boy. Here we go.
Hello, Josh. This is June from Stockton, California. And I got one question. In the Karen Reed trial, if she is found not guilty, can Karen Reed and her family sue the county of Dedham, the court, Judge Cannone, the police department, and the Massachusetts State Police? Does she have any recourse for a civil lawsuit against the state of Massachusetts, or any type of standings for a civil suit? Thank you, and have a wonderful day.
Thank you so much, June from Stockton, California. Let's first of all make sure that you make it on the map. Good question. A question I've seen before too. Not even, this is in relation to Karen Reed, but it applies to any defendant who, you guys have been watching and you feel like they may have been done wrong or done dirty by law enforcement and the county and prosecutors and everybody else. What can they do? Well, sorry to disappoint, June, but it's probably very little, if not nothing. First of all, you're right. If they have a chance of doing anything, they've got to be found not guilty. And that is, by the way, not guilty across the board. So every single count, not guilty. Not hung, not deadlocked, not mistrial, not guilty. That's the starting point. But then they've got to deal with two different types of immunity. First, prosecutorial immunity. This is an absolute immunity for prosecutors, where unless they commit a crime, in other words, they plant evidence or lie about things, they act outside of the scope of their duties, in other words, things that they do while not being a prosecutor, or there is some sort of malicious intent that you can prove behind what they were doing. Not that they're aggressive, not that you don't agree with them, not that they tried to prosecute someone that you feel like was innocent, but malicious intent, ill intent, illegal intent. Getting past all of that, it's an absolute immunity. You never see it. Never happens. Unless the one thing you remember Nyborg out of, I think it was North Carolina. And this was and I didn't prep Kaylin for this because I'm thinking of it right now. This was the Duke lacrosse team. They were accused of the assault of a woman. Horrible case. Everybody up in arms. Prosecutor went after him. Well, we find out later the prosecutor was dealing with a bunch of bad evidence and dealing with false evidence. Michael Nyborg. Yeah. Nifong, says Johnny Knoxville. Let me give him a shout out here for showing that. Yeah. He got brought up on charges for this because he was not able to enjoy that prosecutorial immunity because he had acted with such malicious intent and perhaps even criminal intent. So that's how far you have to go. And that I don't think we're anywhere close to when it comes to a case like Karen Reed. The other thing is with law enforcement, you're dealing with qualified immunity. And you may have heard this before, that it protects them in the exercise of their duties as a law enforcement officer, unless they can be exposed to civil lawsuits if their actions violate what are called clearly established constitutional rights. In other words, you can prove that their search, their seizure, their arrest was not, there's no argument that there was any probable cause for doing what they did. And they acted so outside of the standards of a reasonable officer that therefore they might be exposed to civil liability. Again, does that exist in the Karen Reed case? I don't think so. If they can catch these cops red-handed, planting evidence, manipulating evidence, doing something like that, then absolutely. But if it's a bunch of kind of argument and conjecture based upon the defense, even though that may be good suspicion, argument, and conjecture, it does probably not rise to the level needed to pierce this qualified immunity for law enforcement. So sorry to disappoint June, but I don't think we'll be having a civil case on this case anytime soon. But great question and appreciate you asking. All right. Oh boy, here we go. Buckle up, everybody.
Hello and happy Sunday Funday to all my crewmates, guests, moderators, and of course, Joshua. This is Alicia K. Mayo from West Tennessee. I heard a story the other day and it got me to thinking. Apparently over in the UK, and shout out to our UK friends, there was a young man named Nicholas Prosper who annihilated his mother, his sister, and his brother, and he planned to do a school shooting. As a matter of fact, his idol was Lonza of the Sandy Hook Elementary shooting. And his lawyers try to use autism as a mitigating factor, and the judges in UK said no. So my question is, since our laws are basically based on UK laws, is that a way or something they could cite in the Bryan Kohberger case as a reason to completely toss out the autism defense excuse or mitigating factor? All right, that's all I got. Y'all have a great rest of the day. Bye.
Thank you so much, Alicia K. Mayo. It's not a Sunday Fun Day if we don't hear from you. Appreciate you calling in from West Tennessee. We made sure to be very specific about West Tennessee, putting you on the map. Appreciate that. And you bring up a case that I had not heard of, so I appreciate that as well. Nicholas Prosper is a case out of the UK. This young man was 19 years old, and he admitted to using a shotgun to kill his mother, Juliana Falcone, his sibling, Kyle Prosper, who was 16 at the time, and Gazelle Prosper, who was 13 at the time. Absolutely just horrific, horrible, horrible, horrible crime. They lived in Luton, I hope I'm pronouncing that right, Luton, England, and this happened in September of 2024. So, interesting thing here about UK law that I was not aware of, and that's why I appreciate Alicia K for asking this question, is in the United Kingdom, they don't have what we would call life without parole, or LWOP. They call it a whole life order. And I actually like that. Meaning, let's take the confusion about this. When we say life, we're putting you in for your whole life. It's a whole life order. It's a life without the possibility of you ever getting out. But in order to do that, there need to be certain aggravating factors for the judge to find in order to sentence someone. Luton, pardon me. Thank you, Lily Paul. Luton, Luton, England. In this case, it's multiple murders and significant premeditation, because there was evidence that he, actually planned on committing a school shooting after this before he got caught. However, the judges in this case only sentenced him to life, but with a minimum, meaning what we would call eligible for parole at 49 years. And the mitigation that they found in that case was his age at the time, his lack of a criminal record, which is astonishing to me that a man who would commit this kind of violence would not have a criminal record. But also they pointed to undiagnosed autism spectrum disorder as being part of a mitigating factor in all of this. And Alicia K. Mayo asks, what effect could this case have, if any, on the Bryan Kohberger case? The short answer on that is none whatsoever. And yes, though we can trace some of our criminal jurisprudence to the way things are done in England, we don't take any kind of marching orders, and we don't consider the way that they handle their cases as precedent in the U.S. Attempted autism excuse burns my biscuits. I appreciate that. I like that. And in fact, you even saw when they were making arguments about the death penalty in the Bryan Kohberger case, they tried to cite kind of the world's perception of the death penalty and how other states have handled it. And the judge kind of was like, listen, great. This is Idaho. In Idaho, we have the death penalty, and that's how we handle things here. So give me something from Idaho if you want me to consider it, but I'm not considering other states, other countries. This is Idaho. And that's how they would handle it in most states anyways. And also, the judge has considered it here, and he's going to allow them to use it as a mitigating factor if they get to that point. But it won't become a factor in the guilt phase. If we get to a penalty phase, they can argue it. There's nothing disqualifying him, and that's the difference. The court, the Bryan Kohberger team, are trying to have him disqualified from the death penalty because of his diagnosis of ASD. The judge has said that's not disqualifying, but allow you to argue it as I would allow you to argue pretty much anything about his character when it comes down to the penalty phase, if we get there. So great question again, hailing from West Tennessee. I appreciate you always. Let's keep it moving here.
Hey Joshua, Raffaella here from Melbourne, Australia. I've been following the Laurie Vallow case closely and really appreciate the thoughtful, detailed way you break everything down on your show. I have 3 questions for Sunday Funday. In Laurie's infamous text, quote, Ned must have changed it before we got rid of him, unquote. Do you think the defense, I guess Laurie, could have used the timing of the spirit possession beliefs to create reasonable doubt? Because by February 2019, after that girls' weekend, Laurie and Melanie Gear believed they had cast out Ned Schneider and Charles was supposedly possessed by a different spirit. I think from memory it was either Garrett or Garrick. If that's true, couldn't Laurie have claimed that, quote, getting rid of Ned, quote, referred to a spiritual casting, not Charles's death? It seems like no one caught this point, or at least it wasn't raised in court. Do you think the defense, aka Laurie, avoided it because highlighting her belief system in too much detail could have done more harm than good? And is it possible that the prosecution ran with the text as it appeared to all of us as something ominous because Laurie's hands were tied when it came to explaining the twisted belief system behind it? Thanks again for all your brilliant coverage. I look forward to your thoughts on this. Best wishes. Aussie, Aussie,
Aussie. Oh, I love it. Raffaella from Melbourne, Australia. Let's put it. Oh, yes. Did we not have Australia on the map before now? Look at that. Way to go. We got to somehow breach our way into South America and Asia and Russia there. We're looking a little sparse on those parts of the map. Anyhow, maybe I need to start speaking other languages is the problem. Anyhow, beautiful question. Love this question. this got me thinking. I had not thought about this angle, and that's why I love Sunday Funday so much, because you guys bring up questions I never would have thought about. So let's get to the second and third parts of your question first, Rafaela. But you ask, did she not bring up the idea of the religious elements, talking about Lori Vallow? Did the prosecution kind of run roughshod over her case because they knew she would not get into the religious elements? Obviously, I have no idea what takes place between the two ears of this woman. But my feeling is no. I have a feeling that if she wanted to explain the religious elements, she would have, you know, it didn't seem to me like she was too shy to get into whatever she wanted to get into. And I don't think the prosecution was taking advantage of anything. I think the prosecution was presenting their case as they believed it. And I believe they felt that these discussions of getting rid of Ned were authentic evidence of conspiracy to kill him. But Rafaela brings up such an interesting point of, could she have argued that Ned being this evil spirit, that the reference to getting rid of Ned was more of a reference to a spiritual casting or exorcism of Charles rather than it was of killing Charles? What a brilliant way of arguing that. She obviously did not. She obviously either didn't believe that or didn't think of that. But I thought that was such a great question, such a great way of thinking about that case, and probably something that in the hands of a skilled defense attorney they could have made, because I do think there was room for argument in this case. I said that from the beginning, that people saying they don't like someone, they would benefit from someone's death, they don't want somebody around, is very different from planning someone's murder. And we talked about conspiracy a little bit before. And I think this case had some issues with conspiracy, but the jurors obviously saw it a different way. And I think we're all happy that they did. Thank you so much, Rafaela, from Melbourne, Australia. And thank you for putting Australia on the map. And let's keep it moving here.
Hey, Josh and crew. This is Kathy calling from upstate New York. Anyway, I was going to ask this in chat, but I decided I'd go ahead and leave a message. With the objection thing, no speaking objections, am I correct? And if so, how come sometimes they object and she answers and other times they go up to sidebar? I probably should know this, but I don't. So, thanks. Bye.
Thank you so much, Kathy, calling from upstate New York. Let's put that on the map. This is about the Karen Reed case. This drives me nuts. And you're already, it's giving me flashbacks and PTSD from the first trial when we dealt with so many of these sidebars, because half of the time the attorneys don't know, or the judge doesn't know what the issue is being objected to, and they are not allowed to even state the grounds for the objection. There's a difference between speaking objections and stating the grounds, by the way. Speaking objections means you don't get up and say, Your Honor, this is hearsay. This witness doesn't know what they're talking about. They heard this from someone else and they can't be trusted. That's a speaking objection. She doesn't even want the grounds. She doesn't want objection hearsay, objection foundation, objection relevance. She doesn't even want them to state the grounds, which to me is too much. And it's dragging this whole thing out. And what is the harm in stating the objection, the grounds for the objection? Most judges say no speaking objection, but saying don't even state the grounds, I feel, is going to create a lot more sidebars. And that's why this case is going to take a lot more time. And it is infuriating, and I don't understand it. And I don't know who she's protecting. And I don't think the jurors imaginations will run wild just because they heard the attorney say the words hearsay or relevance. So anyhow, the answer is that's the way the judge wants it. That's the way it's going to be. And that's what we're all going to have to suffer through. But thank you so much, Kathy, from upstate New York, for calling in. Appreciate you. All right. Where are we going now? Ooh, we're fueling up the jet.
Hi, Josh, and all the Courtroom Confidential crew. This is Black Widow in the Republic of Ireland. Just wondering, how do you cope with the fatigue at the end of a trial? I mean, I haven't even done any work. I'm just watching it, and I'm exhausted after every trial. What the hell is going on? How do you not be tired from all that information? Tell us, a wise one. Thank you.
Oh, Black Witter from the Republic of Ireland. Thank you so much. First of all, let's make sure that you make it on the map. Appreciate you calling in and representing Ireland. Great question. And I will tell you, it is exhausting. And it's this weird kind of exhaustion too, because it's an exhaustion from when you're coming down from a high. So when you're in court in trial, you can watch these attorneys. They are listening to every word. They're taking notes. They're objecting. They're questioning. You have to be all pistons firing, all synapses firing. And you do that all day long. And then the judge says, okay, we'll see everybody tomorrow. And you can just feel your body crash. And Tiffany will tell you this. I would come home from days in court and I'm just spent. She says, what do you want for dinner? And I'm like, you decide. I'm done deciding things. I'm done thinking. I'm just going to sit here. I'm going to veg out and I'm going to look at TikTok and I'm going to watch TV that I'm not even listening to. And I'm just going to let the world kind of wash over me. It is really exhausting. And then Black Witter, you got to then gear up and do it all again tomorrow. And when you're in a case, as long as these guys are in for like the Karen Reed case or Bryan Kohberger or some of these big cases coming up, you're talking about weeks of doing this. Most trials, by the way, last days. You maybe you get 5-7 days out of the whole thing, including jury selection. These trials are lasting weeks and weeks and weeks. And I've handled a few trials that are that long, and they are marathons and they're exhausting, and your sleep suffers and your health suffers and you're not eating well. You're half of the time you're just grabbing something at lunch and you're not eating well. It is exhausting. So thank you. And thank you for calling in from Ireland. Appreciate you. All right, let's keep it going here.
Hello, Courtroom Confidential. This is Sonia in Chicago. I've missed you guys. I know I've been away. And I just have a question, Josh, about how you handle your down moments. In other words, when you start, I don't know, when you don't have those sunshine glasses on and you're just, everything is getting on your nerves. Your client is getting on your nerves. Maybe you're thinking, you know what, this guy's guilty. What am I even doing? Like you have those doubts and just bad days. How do you just act as if that you're not having a bad day? Because how do you get through those moments where you have maybe a lot of doubt or maybe you're regretting, defending somebody? How do you work through those times? Do you have a confidant? Do you go running? What do you do to resolve some of that stuff? Thanks. Bye, guys.
Thank you so much, Sonia from Chicago. Let's put Chicago on the map. God, what a great question. How do you handle bad days? How do you handle the doubt and regret, perhaps from defending someone? And it happens, by the way. There are clients that I will get a phone call or a text message, and I can feel the anxiety well up inside of me. And you're done with the case. You're done with that client. It's been around forever. You don't want to think about it ever again. And sometimes the best day is the day that you finish a case or you get fired. They hire somebody else and you're like, oh, thank you, Lord, that this problem, this heartache and headache and heartburn has moved on to somebody else. But this is part of the job, and you get through it and you try to compartmentalize, and I'll work out and I'll sweat. And I'll tell you what, more than anything, these two little critters right here are what get me through everything. Those are the two of my three girls. This photo is actually a few years old, but I get through a whole bunch by coming home to them and my beautiful wife Tiffany, and they are my support and get me through a lot. So I couldn't be doing it without them, and that'll get you through a lot of doubt and regret and bad days. So thank you so much, Sonia. That's right. Crazy Mom RN says that's what it's all about. Absolutely true. Thank you, Shy Gal. All right, let's keep it going here.
Hi, Josh. My name's Maggie. I have a two-part question. I was just doing a rewatch of the Robert Tellis trial because I'm cool like that. First of all, have you heard of that case? And if so, what did you think about it? What did you think about his defense, the prosecution? What did you think of it? Second part of my question is, when the defendant took the stand, his attorney had him do a narrative testimony instead of asking him questions. I was just wondering if you've ever seen that before in your career, as I've heard that a lot of times when defense attorneys have their clients do a narrative, it means that they believe that they're going to potentially lie on the stand. So yeah, I just want to know if you've had any experience with that, what your thoughts on narrative testimonies are, and just what you thought of that case. Thanks.
Thank you so much, Maggie. And I see you're in the chat and you're from Ohio, but we didn't know that, so we couldn't put you on the map. So next time, now you owe us a call next time, Maggie, so that we can put Ohio on the map. But great question. I like that you spend your spare time watching old cases. Robert Tellis is one for the record books, by the way. What you want my impressions of this case and the defense? I thought it is rare to have seen a true sociopath and narcissist in the flesh, and that's absolutely what I believe this gentleman was. It was fascinating to watch. The case itself was interesting because there was the circumstantial evidence about the ridiculous hat he was making. There was the wearing the dress like a gardener type of thing he was wearing the reflective vest and all of this stuff. It was a wild case with, murdering a reporter, Jeff Gehrman, just all of it. But honestly, the most fascinating part of it was the accused himself, the defendant himself. He was an absolute, I'm no psychologist, but if there's a sociopath and if this is what it means, I believe that he absolutely is what it is. And a pure narcissist, and just thought he was smarter than everybody in the room. And you ask the question of what is this whole narrative testimony stuff all about? And you're right. There's competing concerns here. One, a defendant has a right to testify. That is a constitutional right to defend yourself, to get up and tell your story. Two, an attorney has an obligation to not suborn perjury. An attorney, as a defense attorney, can make arguments, can get pretty darn close to questioning the truth, but you cannot tell lies. You cannot get up and have a witness that is going to lie to the court. As an officer of the court, you cannot put a witness on the stand that is going to lie. So what do? If you've got a client that wants to get up and tell something that you believe to be not just an interesting take on the evidence, but a lie, how do you handle that? Well, the courts will allow, with permission, for this type of testimony, which is called narrative testimony in the narrative form, which then it's the attorney is seen as not taking part in suborning it. They're just, Your Honor, our next witness is Mr. Tellis. And he gets up and he tells his whole stupid, goofy story, and you don't lead him through it. And so you're not taking part in it. And that protects the attorney's obligations to the state bar and ethics rules and everything else, and allows Mr. Tellis to exercise his constitutional rights And then if you watch this, and by the way, we have a video, don't we, Kaylin? We have a video of us watching it. So if you want to go back and watch his testimony, where we sat down, meaning myself, and we watched it and kind of analyzed it, please check it out. I'm going to throw this at Tiffany and Kaylin on the fly. If we can find a link to that, we'll share that with you guys if you want to watch it. But fascinating case. Thank you so much. Maggie from Now We Know, Ohio, with that question. All right.
Hey, Josh, this is Debbie from Atlanta. And I had a question about, and I guess it's a cold case now or unsolved case that happened here in Atlanta, July 28th, 2021. I had to look it up. But a girl named Katie Janness, a woman named Katie Janness, and her dog Bowie were both stabbed and murdered at the entrance to Piedmont Park, which is a huge park here in Atlanta. And they have no leads or anything. They do have her on, camera walking across, but it's just never been solved. Nothing has ever happened. And I was just wondering, is it just go cold, or are people still working on it? I don't know. And you may not even know, but anyway, it's always bugged me. So I thought I would ask you. Thanks. And I look forward to Sunday Fun Day. Bye.
Thank you so much, Debbie. Let's put you on the map. Atlanta, Georgia, calling in, representing Atlanta. I remember this case. This was a really horrific case that took place. This was July 28th of 2021. Katie Janness went out for an evening walk with her dog, Bowie. Never returns home. Police go out looking for her. She is later discovered. I'm not sure if it was police or some other person discovered her and her body. Both her and her dog, Bowie, who looks a lot like a dog I used to have named Penny, are stabbed to death. And this is in Piedmont Park. She had 50 stab wounds. She was stabbed all over her face, neck, and torso. Her body was mutilated, and the letters F-A-T, fat, were carved into her torso. So this, has got to have law enforcement's heads absolutely spinning, because this doesn't look like some robbery gone wrong, some assault gone wrong. This looks like some sort of targeted attack. If it is an act of complete randomness, why the hatred? Why the quote unquote overkill? Why 50 stab wounds? Why take the time to mutilate her body and carve that word into her body? Why? What person was possessed with this? Why the hatred towards her? Why was she targeted? Was she targeted? Was it random? All of these questions continue to remain unknown. And the answer to your question, Debbie, is I looked this up. There are still no suspects. We are now going on 4 years. And to your question, does it just go cold? Cold isn't some sort of official classification. It just means that it's a case with no current unexplored leads, right? That they've spoken to, collected evidence, talked to witnesses, everything that they could possibly do. And now they are just kind of waiting. And I guess that is what you would call cold. They're waiting for perhaps some breakthrough, someone to come forward. It's not like at all this time they're waiting on forensic evidence to come back. DNA evidence, I imagine, has been collected. Maybe even DNA evidence of a suspect has been collected, but it's not popping up. It's not in CODIS. It's not matching to anyone. It's a really disturbing case. I'm curious, Debbie, what the community there is feeling about all of this. Afton says overkill or mental illness. Who knows? Yeah, you're right. Could absolutely just be a random act of someone who is mentally unwell. But then how do they get away with it? How do they not be spotted by anyone? How are they not covered in blood? How has no one come forward to say, I believe this person was involved? And then they take the time to, like I said, stabbing someone 50 times is a very physical act. It's exhausting. And then to stick around and mutilate her body, carve those words, it had to have taken time. Really nightmarish type stuff. So, I hope that puts you all in a fantastic mood to think about all of that. But I am very appreciative to Debbie from Atlanta for asking the question. Kelly Can't Get Right says, sorry I'm late. Was the first question Tuscaloosa? No, the first question was not Tuscaloosa. Caitlin's barking something at me. All right. I don't know what's going on. Anyhow, let's keep it going along here.
Good morning, Courtroom Confidential friends. This is Terry L. from Tennessee. I'm calling with a question about a recanted testimony in a pretty old trial. There was a young lady in our area named Holly Bobo that was kidnapped and murdered about 7 years ago. And it took 3 years to find her body. And this was all big. It's actually the most expensive search in the state of Tennessee history when they were trying to locate her. And the person that was eventually found guilty for her kidnapping and murder has gone before a judge for an appeal because the primary witness, who was also a co-defendant and got a very sweet deal, has recanted his testimony. And it was a pretty weak case to begin with. Although most people are convinced he did it, some people aren't. And I'm just curious, how often does this happen? How likely is it that they'll get a new trial, or can we just rely on what was said under oath? Because it's a pretty unreliable witness either way. It's just kind of an interesting case if you want to look into it. Her name was Holly Bobo, and I'm just curious if he's really got a shot, and if he's going to get a new trial. How does that work? We just start all over? Do they release him, or what? Hope we have a great Sunday fun day.
Thank you so much, Terry from Tennessee. Another putting Tennessee again on the map. We're doing well out of Tennessee today. And I saw that, yes, Tuscaloosa was our first question. Thank you, everybody. From Tuscaloosa was our first question. So I appreciate that. All right. This is another case I had to look up. I was not aware of this case. So thank you so much, Terry. Holly Bobo. Yes. Awful case. Awful tragedy. She's 20 years old. She disappears from her rural home in 2011. Her body is not discovered for 3 years, and it does become the largest police investigation in Tennessee history. Finally, a person by the name of Zachary Adams is convicted in 2017 for her rape, kidnapping, and murder, and he is charged along with a man by the name of Jason Autry and another person by the name of John Dylan Adams. And during trial, the way that they were able to pin this in part on Zachary was through the testimony of Jason Autry. There was no DNA. This is 3 years later, remember. No DNA. It was purely from the testimony of Jason Autry and other kind of informants, the people that Adams had spoken to, I think, while in custody, that they're able to pin this on him. Jason Autry, in compensation for his cooperation, only gets 8 years in prison. John Dylan Adams gets 35 years, but Zachary Adams is seen as being the primary aggressor, and he gets life. So why are we back in court talking about this? There is a petition out of Tennessee. I've never heard this term before. It's called a coram nobis. Essentially, Autry met with a forensic neuropsychologist in December and admitted that he made the entire story up. He says that his lawyer pressured him in 2017 and said that if he went to trial, there would be a 95% certainty that he would be convicted. And so therefore he decided the only thing he could do was make up this entire story and pin the whole thing on Zachary Adams. He's now recanted his testimony. So to your question, Terry, how often does this happen? Answer is not all that often, but it does. Will this get him a new trial? And the answer is likely no. No one ever thought this was the most believable guy to begin with, Zachary Adams, or pardon me, Jason Autry. There is other evidence. There is evidence that, things that he testified to could only be by somebody who had witnessed the murders. There is other kind of corroborating circumstantial and forensic evidence backing this whole up. But basically what it comes down to is that a judge is going to have to make the decision of which is more believable, the testimony that he gave back then or the recanting of that testimony now. I'm not saying it's impossible. I'm saying it very well could lead to a new trial if they feel like the entire case hinged upon this and that his recanting of this is to be believed. But again, you're talking about, apparently Adams had also made comments to other people about his involvement. So if I had to lay bets on this, I would say it's not going to change anything, but it is interesting that after all this time, Autry's now decided to change his story. So thank you for bringing that case to our attention, Terry. One that I was not aware of, but I will continue to follow now. All right, let's keep it going here.
Hey, Josh, this is Gloria from Florida. Regarding Karen Reed and her statements to the media, I agree with you that she's got no one else to blame but herself for these statements, and the prosecutor is using them very judiciously. And I wonder, too, the surveys that the jurors had to complete before they were chosen, what kind of questions do you think they put on there, both prosecutor and defense, to kind of determine how to feel a person out about how they feel about drinking and driving, being teetotalers or drinking a little bit or being buzzed? How would they word those questions to ensure that they get the right people on the jury for the way they want them to think about a person who drinks rather heavily and gets into the situation that Karen is finding herself? She's doing herself in talking about how the drinks were weak, and so she had to buy a shot to add to the drink, and John was helping her with that, and she just really sounds like a heavy drinker. Okay, thank you. Bye.
Thank you so much, Gloria from Florida. You ask about the Karen Reed case and the questionnaire that was used in that case. And what kind of questions would they put on it? Well, we don't have to guess because, hold on. I am going to share with you. Oh boy, did I do this wrong? How do I do this? How do I forget how I did this before? Oh, here we go. Oh, bear with me, guys. Sorry. This is me still figuring out computer stuff. There we go. We don't have to guess because here's the actual questionnaire. And it asks questions like, first of all, it tells them that this is involving an it is alleged that on this date, while intoxicated, she did kill her boyfriend with a police car. Are you familiar with this case? Or is there any reason you can't be fair? Have you ever served on a jury before? They talk about religious beliefs, media attention. Are you close friends with anybody in Canton, Massachusetts? Do you believe officers over anybody else? Do you disbelieve the officers over anybody else? You know, these are kind of the questions that they would get to in a normal voir dire anyways, but it through this questionnaire, it kind of allows them to short track all of that they get these people answering this, and then they can identify which people they want to actually talk to. Do you support law enforcement? Are you super critical of law enforcement? Yeah. Do you, are you a part of MAD? Or do you have a special feelings about drunk driving? Have you ever been involved in an incident with drinking and driving? Have you ever been involved in an auto accident? You know, this is all the kind of stuff that you would expect, you would want to know out of jurors in a trial like this. Do you believe Karen Reed should have to prove her innocence? You know, just basic questions about the burden of proof and presumption of innocence. So, and then the last page goes on to ask them to say, where do they get their news from? You know, what TV, radio, newspapers, internet, TikTok, Twitter, the Courtroom Confidential YouTube channel. Where are you guys learning about this? Please tell us all of that kind of stuff. So great question. There's the questionnaire. We don't even have to wonder what they put on it because we could read it. And I am proud of myself. I was able to figure that out without Kaylin's help. So I'm going to pat myself on the back for that. Kaylin just looked at me like, you're on your own, sir. All right, let's get it moving along here. Now I messed up, by the way, Kaylin. Now I messed up I don't know how to get my thing back on here. So let me figure this out.
Hi, my name is Jen. I'm calling from Ontario, Canada. I love your show. I want to know, why was Chandler cop body cam excluded from the Lori Daybell last trial? I'm referring specifically to wherein Charles was cogently begging for the cops' help. That may have avoided so much future catastrophic mayhem. And please don't say, because Charles is deceased and unavailable for questions in trial, Tylee and Alex's names and etc. were used in the trial. They wouldn't have been able to answer questions at trial. Not to mention, had all of Chandler Police Department police executed their jobs more thoroughly, perhaps Charles wouldn't have died horribly in the first place of all this awfulness. Thank you.
Thank you so much, Jen from Ontario, Canada. And I know you said, don't tell me it's because he's unavailable for trial, but I'm going to tell you it's because he was unavailable for trial. But I'm going to put Ontario, Canada, first of all, on the map. But this is the piece of video, and I'm going to share it with you guys now. Okay. Yep. Here we go. This was the body cam that Jen is referring to, and I'm just going to play a couple of minutes of this so that you hear the part we're talking about.
So what's going on tonight?
I can't get in touch with my kids.
How old are your kids?
6.5 and 16. Okay.
How long have you been trying?
2 days.
Okay.
But she's lost her mind. I don't know how to say it. We're LDS. She thinks she's a resurrected being and a God, and remember the 144,000. She's come. Jesus is coming next year. She took all the money out of her bank account today. My truck has gone from the airport. She went to the airport and got it. I just flew in from Dallas. Houston and Dallas. So
where's your truck?
I don't know.
Okay.
A friend of mine's truck picked me up. I went to the CSI to file a report, which is the community bridges or something. File a report.
So you did the petition?
Yeah, they ordered pickup.
Okay. What time did you do that?
Hour and a half ago.
Okay. So what makes her a danger to herself and to others?
Threatened me, murder me, kill me.
She threatened to murder you?
Yes. And she said,
how did she do that?
My bishop right there is in the car. He was on the phone with me today when she said, I will have you destroyed, is what she said there.
Okay, that's not a threat to kill you.
Yesterday was a threat to kill me.
Okay. What did she say yesterday?
She said, you're not Charles. I don't know who you are, what you did with Charles, but I can murder you now with my powers.
Okay.
Okay?
All right.
So I'm gonna kill you too. Yesterday was
So she's speaking as a spiritual being.
She's not here. She's lost her reality.
Is this just all recent, or has it been going on?
Been going on for about 4 or 5 years. It's gotten really, really bad lately. She goes to the temple every day and speaks with Moroni and Jesus Christ, and they tell her what to do. And now she came to her today, and last couple of days she says, I'm not Charles. You're not Charles. You're Nick Schneider. I don't know where she gets his names from. She got all this stuff from these people in Utah who tell her how many past lives she's had and probation she's had. And she's was married to Moroni way back when. And
so when you came back, why didn't you?
All right, I'm gonna stop it there because it's a longer interview, but I don't want to take up our whole morning listening to the whole thing. It's about 15 minutes long, but you get the point for Jen's question. Why didn't they use this? Why couldn't they use this? So the answer is what you told me not to tell you, but it is about hearsay. Hearsay is any out of court statement being offered for the truth of the matter asserted. Okay. This is an out of court statement. This is a statement that Charles made out of court. He's speaking to an officer. Is it being offered for the truth of the matter asserted? It is. It's being offered to prove that she was intending to kill him. If it's not being offered for that, then what is its relevance? If it isn't being offered to prove the truth of the matter asserted that she was attempting to kill him, it has no relevance and shouldn't come in. So it is hearsay. Now, does an exception apply? So you've established this is hearsay. What exceptions apply? Well, it's not a dying declaration. He's not on his deathbed. It's not an excited utterance. He's not, you could argue perhaps that he was in the recent kind of emotional charge of having just experienced her threatened him with her life, but I don't even think that applies. So there really was not an exception here to allow this in. So this is the kind of stuff that you see where it's powerful evidence, but it doesn't come in because he can't testify to it. If he could take the stand, but he's dead because she took his life or took part in that, he could say she had threatened me before. She had said X, Y, and Z, because now you're not talking about hearsay. Now you're talking about, yes, a prior out-of-court statement made for the truth of the matter asserted, but it's a party admission being made by the defendant, and he could testify to that. So that's why, without him taking the stand, this video was not going to come in. But great question, Jen from Ontario. Video was hearsay, but why not question the cop? Because the cop would have to talk to what he said. So now you're talking about two levels of hearsay. It would be the hearsay from Charles to the cop and from Lori to Charles. So Lori says, I'm going to kill you. That's one level. And then Charles says, Lori said she's going to kill me. That's level number 2. And you've got to have now 2 exceptions to why that officer could testify to that. But great question, guys. I appreciate it. Johnny says, chipping in for a flame suit, Josh, for the Nancy Grace appearances. Love her show, but her guests definitely get cross-examined. And she wants me to fight with her, by the way. She does not like when I agree with her. I appreciate you, Johnny. But if I don't get on there and fight with her, she gets upset with me. So that's why we have to tussle. And she does like to then, she likes me to take a position that makes me sound like an idiot and then chop me apart for being an idiot. That's her show. But thank you, Johnny, for that. All right, let's keep it going here. Just a couple more, guys. Stick with me. We're almost done. I promised. Who is it that I promised? Kathy, you will be able to watch NASCAR. I am not going to mess with your NASCAR. Here we go. Oops. Oh, they.
And CC crew, it's Joy W from Ottawa, Canada. I just have a question regarding the search and seizure, and it's sort of regarding the Maddie Soto case and Stephan Sterns' phone. In Canada, we have the Charter of Rights and Freedoms, which is comparable to your Constitution. And I was doing a bit of research because ours is a bit different. And I think the big phrase within ours, Section 8, is the totality of the circumstances. So that gives a little bit of leeway. And so it's not totally the fruit of the forbidden tree. I don't think we have that phrase in our legal system. I had first found you through Ian Runkle of the Bailey, when you had him on doing the conversations on a Monday evening, I believe. And he gives a good example of, a rolling stop with, a van goes through a stop sign and a police officer stops him. And on looking in the van, he sees, like, Ian gives these wild examples, a nuclear weapon, 500 kilos of coke, and a woman that's been kidnapped. That would all be allowed in, even though that wasn't part of the initial traffic stop or the reason for the initial traffic stop. So I'm just wondering if you could give an explanation of how much leeway that the police or the judge in this case has to allow all this, to allow the search of the phone and the pictures that were found there. How much leeway do they actually have to allow that in? Anyway, thanks very much.
Thank you so much, Joy W from Ottawa, Canada. Let's put Ottawa on the map. Great question. And I want to give a shout out to Ian Runkle for we did do a conversation with him. If you guys are big fans of Ian, check it out. It's one of our videos that you can check out in our playlist on the conversation series. And Ian was a real trooper for helping us out and doing that conversation with us. So thank you again to those of you who found us through Ian, and he's from Canada. The question becomes, really, I think what your question is, Joy, is how does kind of probable cause work when you're talking about searches and seizures of property? It all starts with the question of, was this, and this, we're dealing with the Maddie Soto case, really tragic, horrible case here, and Stephan Sterns. And anytime you're talking about search or seizure or Fourth Amendment issues, you start with, was there a warrant? If there's a warrant, it's a totally different question. If there's a warrant, you usually don't have any problems. It comes down to what was in the warrant, and then you're attacking the warrant. Was the warrant sufficient, deficient, problems with the warrant, whatever? If you don't have a warrant, you take a different approach. And now you're talking about probable cause and what allowed the police to essentially break someone's Fourth Amendment protections without a warrant. What are the exceptions that will allow for that? And so you're dealing with different levels of probable cause. Well, you outlined some of them, Joy. One would be, like Ian said, if you're walking up to a vehicle and you see an atomic bomb in the back seat, that would be considered plain view. Police don't have to ignore something that is in their plain view. You can also search someone incident to arrest. You find someone, you're arresting them for graffiti, for vandalism. You arrest that person, you're going to search that person before you put them in the back of their squad car. And if you happen to find a kilo of coke inside their pocket, you have probable cause to seize that coke, even though you weren't investigating them for drug possession. A safety pat down, even. Police have not arrested you. They've just detained you. They're trying to investigate something. They don't have enough to arrest you yet, enough probable cause, but they're going to perform a safety pat down to make sure you don't have any weapons on you. And lo and behold, they find that you've got an AK-47 in your back belt, in the back of your belt. That they can seize. That is seen as probable cause. things like exigent circumstances. We couldn't get a warrant to go inside of the home because we were chasing the man who was covered in blood with a knife in his hand, and he ran inside of that home, and we had the exigent circumstances of public safety, and that's why we had to run in there after him without a warrant to go inside the home. And finally, something like consent. And that's what we're dealing with here in the Stephan Sterns case. The issue here is with consent and the scope of consent. So you can limit consent. You can say things like, they want to say, can we look at your phone just to, you say, well, I texted that person to leave me alone weeks ago, and therefore that's why I'm not involved in this crime. I don't know. I'm making something up here. You can say, I'll let you see my texts. Now, have you limited the scope of them getting inside your phone? If they open up your phone and they look through your texts, and then they look at your bank account, and then they look at your Google Maps, and then they look at your photographs, and then they look at your calendar, is that exceeding the scope of the consent that you've given to them? Or if they say, hey, can we take a look at your phone? And you say, sure, is that unlimited consent? Many would argue, yes, it is. His position, Stephan Sterns, and I realize that's not entirely supported by the evidence. The evidence is that they were asking for and receiving consent from him along the way. But they're saying that he is saying, pardon me, that he only gave limited consent to look at his Google Maps, and that the police got his phone and looked through everything. Now, I know there's this issue about he had factory reset it, and he thought there wasn't any evidence on there, and police stumbled upon evidence that showed the assaults of Maddie, and that's why they went into it, and they were looking for a missing person at that time in exigent circumstances and everything else. And you can see how these arguments will play out in court. But to your point, Joy, this comes down to, and is going to come down to, a very significant question on consent and the scope of consent given, and what proof the prosecution has of consent. Was it written? Was it oral? Was it recorded? We're going to have to find out, and they're going to have to prove it, and a judge is going to have to decide. And my whole point, we covered this and talked about it in the weekly roundup. Check it out if you guys haven't already. This is huge. The police are acting in a fluid, moving situation. They've got to find this girl. They've got a guy who's a suspect. Situations are unfolding in real time in front of them, and they don't have time to sit down with attorneys and case law and research all of this. They got to make decisions. And could those decisions have very huge consequences down the road? And the answer is yes, they could. And a judge could decide they didn't have consent, and they're throwing out the whole phone. And to your point, Joy, it's the fruit of the poisonous tree, meaning everything else after that. And this could be catastrophic to their case. I don't think it will be. I don't think it'll end up there, but that's where this all could go. So thank you, Joy, from Ottawa, Canada, for asking that question. All right, let's keep it going here.
Hi, Josh and Courtroom Confidential. I watched your weekly roundup and have to disagree with you on Karen Reed. I don't care what snippets of Commonwealth shows. I don't care about Google searches and who knew who. I want the Commonwealth to prove beyond a reasonable doubt that John O'Keefe was hit by a car, and I don't mean with Trooper Paul's pirouette and crime scenes that speak to him. If they cannot do that, there are too many possibilities of what happened, and they have reasonable doubt in my mind. Thanks, guys. Have a great Sunday.
Thank you so much, Tracy. I love your question. I just wish you told me where you were from, but I don't. You say you disagree with me. I think we agree. I do agree with you. I think the Commonwealth has to prove beyond a reasonable doubt that John O'Keefe was hit by a car. Right. That is the central question amongst others. But as was identified by Alan Jackson in his opening statement, if he wasn't hit by a car, then we're done here, folks. If he was not hit by a car, that is starting point number one. Was he hit by a car? Then you get to, was it her car? Then you get to, was she driving? Then you even get to, did she know? But if he wasn't hit by a car, game over. It's done. That's the whole prosecution case hinges upon whether or not he was hit by a car. So I agree with you, Tracy. They have to be able to prove that beyond a reasonable doubt. My point in what I talked about in the weekly roundup And I'm sure I got under some people's skin, but my whole point was, listen, you may feel that this investigation had problems and that they were myopic and that they were rushing to judgment and that the evidence collection was shoddy and everything else. And Trooper Proctor, bad guy, bad guy, bad guy. The evils and sins of the law enforcement can easily be forgiven by a jury if they feel like the defendant is admitting to the crime in her own words. That was my point. I've been doing this for long enough to know that what really drives the bus in these cases is words out of the defendant's own mouth. I remember so many times when I was a prosecutor, I get called into my supervisor's office. They'd be like, Josh, we got a new trial for you. It's starting next week. I would go, oh boy, here we go. They tell me about it. You know, we're talking about a robbery. We're talking about a shooting. We're talking X, Y, and Z. They've got forensic this, ballistic that, videotape this, witness that. And then they go, and by the way, he made admissions. And I go, well, what do we, you're burying the lead here, boss. If they made admissions, that is the most powerful stuff in this case. And that will, to me, if Karen Reed is convicted here, it may entirely rest on her. You could place that blame entirely at her feet because she spoke to the media so many times and gave so many statements. Statements like, he didn't look mortally wounded. How do jurors deal with that? What do you mean he didn't look like? You saw him? These are the questions. I get where everybody falls on Karen Reed, and I get where everybody has strong feelings about all of this, but how does a jury who doesn't know any of the history of any of this deal with a statement like he didn't look mortally wounded? They're going to have to deal with that. Defense is going to have to get around that somehow. And if they are going to try to say it, well, you got to take the context and you got to understand and you got to, all of this other stuff, that is a real deep hole to be digging yourself out of. And it's all because she said she wanted to sit down. We're not talking about passing comments to the array of cameras and microphones outside of the courtroom. We're talking about sit down, lights and camera, hair and makeup interviews. And she's making these types of statements. Anyhow, thank you, Tracy. We are good friends, you and I, Tracy. I think we don't disagree. I think we do agree. End of the day is still burden rests with the prosecution, and the Commonwealth will have to prove that he was even hit by a car beyond a reasonable doubt. I agree with you. All right. This is it, folks. We got one more here.
Hello from the Shenandoah Valley of Virginia. I was contemplating about prison, and it would seem to me, rather than having people go in and kind of waste away their lives, we could help the infrastructure by really training them to build better roads and bridges so that they are giving back to society that they took from. For example, in the car accident where the young 19-year-old killed the mother and 3 other children in Washington State, they should be required to give back in more than just studying in rehab therapy. That's my thinking anyway. Have a blessed Sunday. The first shall be last and the last shall be first, since I'm probably the last to record. Bye.
Thank you so much, Annie, from the Shenandoah Valley. And you called it. You are the last one we're talking about today. I know that we got other calls. I know we even got calls while we were doing this, and I'm so sorry. We just can't get to all of them, but we will get to them next week. So keep on leaving those calls. From the beautiful Shenandoah Valley, Annie, appreciate it. I agree with you. I think there should be more of an opportunity for people who are serving their time to be serving their time in a way that is productive to society and everyone else. And there are programs like that. There are programs where they can do work for release programs, where they get work, they can work and get credits against their prison sentences and get released early. In California, we have something called Fire Camp. We got fires here in California, if you haven't heard. And they will have people serving time who say, I volunteer. I want to be part of fighting fires. And will that give me the ability to, 1, not be housed in prison, and 2, earn some credit so that I can get out early. So there are programs like that, and I applaud them. And I applaud you, Annie, for bringing up that point and from calling us from Shenandoah Valley, Virginia. I appreciate you calling in. Everybody, you've been fantastic. We've got a few more minutes before NASCAR begins here. I've been put on a very short leash as far as how much time I can take up on your Sunday, but this has been a very fun Sunday fun day, and I thank you guys all for being a part of it. Here's some quick announcements. What you missed yesterday was our Saturday weekly roundup. We talked about Karen Reed, Lori Vallow, Stephan Sterns, Luigi Mangione, a bunch of other stuff. Please check it out. Bryan Kohberger covered everything that's going on and what you may have missed this week. Stay tuned. First of all this week, we have launched our new live trials channel. It is called Courtroom Confidential Live Trials. But to find it on YouTube, because we're still this tiny little channel on YouTube, you have to search for CC Live Trials. The handle is at CC Live Trials. And we have been live streaming the Karen Reed trial. And we will be live streaming other trials as they begin. And it's just a great way for everybody in the community to get together and talk about it. And it's a safe space and a welcoming place. And we encourage everybody to go check it out. Check out CC Live Trials starting again tomorrow, right? They're picking up on Karen Reed again. So we will see you guys there. And you'll see my face interrupt every once in a while to just kind of give my comments. Jill Argo says, Josh is always terrific. Love his channel. Thank you so much. We're loving the new channel, says Objection Cake. Good. I'm glad to hear it. Monday, we have our brand new episode in our conversation series with Beth Karras. You've seen Beth forever. She had a 30-something year career with Court TV. She talks to us all about that. Really interesting conversation. That premieres tomorrow Monday at 5 p.m. Pacific, 8 p.m. Eastern. Please check that out. Wednesday, we are doing Wednesday Night Live. And our special guest will be Joel Waldman from Surviving to Survive It. Look at him. Look at that nice, what do we call that? 8x10. What do we call that? Headshot that he did there, smiling for the first time. Joel will be on. We're going to be talking about probably all things Donna Adelson, Karen Reed, and Alexander Brothers. So please check it out. Representing the STS Nation. Always a good time when Joel comes on. I really enjoy speaking with him. All right. We reached 30,000 subscribers because of you, fine folks. So you deserve a giveaway. Here are the terms of the giveaway. Tiffany, keep up. I think I'm kind of making this up on the fly. But if you leave us a voice message for next week's Sunday Fun Day, you are automatically entered. And everybody who left one already that I didn't get to, you are automatically entered to win a new shirt. One of our brand new shirts. Do we have pictures of them? Should I put that up, Kaylin? I think I have the website here. Hold on. Yeah. Here's our website, thecourtroomconfidential.com. And if you click on shop, you will see all of our new merch. And these are the new colors. I'm wearing one of them today. This beautiful, I don't know what you call this color, aqua green kind of a color with different logos, different sizes, different cuts, male and female, unisex and V-neck. Anything you guys are interested in. If you win, we will randomly pick someone to tell you the winner at the next Sunday Fun Day. Leave us a message. You're entered to win, and we will send you a t-shirt. And we're opening this up to the entire wide world, right, Tiffany? I think we are. I've just decided that we are. So check it out. This is where you also go to find out about membership. If you guys want to join our membership program, which many of you have, we have a lot of perks there, and we're continuing to work on it. And as always, this is where you go if you want to enter to send us a voice message. You go on thecourtroomconfidential.com and click on that little button that says send a voice message, and we will do what we just did here. Answer them live on the next Sunday Fun Day. All right, guys, that's it. I pulled it. Look at the perfect timing. I can hear them saying, start your engines. Thank you all so much. You're all fabulous. I appreciate you all. Thank you for being here on a Sunday. Have a wonderful rest of your Sunday, and we will see you again next week, everybody. Take care.